Grassroots TV, are we on? Okay, let's start again. Thanks everyone for being here today. And it is Tuesday, August 16th. You are watching a work session of the Board of County Commissioners of Pickens County. It's about 10 a.m. And our first item on our agenda today is the Thompson Divide Coalition. This is an update on the overall issues surrounding the Thompson Divide area and the Thompson Divide Coalition, the history with Pickens County and our association for our new members, as well as to discuss some of the current issues regarding unitization. And so we're going to start with a bit of a refresher for ourselves and the public and a presentation by the members of the Thompson Divide Coalition. So Dorothea, just introduce yourselves for the camera before you speak, and we'll go from there.
Okay, I'm Dorothea Ferris. I'm Vice Chair of the Thompson Divide Coalition, and I'm a Commissioner for the Colorado Division of Parks and Wildlife. And there's a relationship there, so that's why I mentioned both. Roy Stevens is the Office Manager for Thompson Divide, and Peter Hart is here, and he works with us as giving us legal advice. I'm going to go back into, since you've been generous enough to give us a lot of time, I'm going to spend just a couple of minutes talking about why this is so important to me. When I first got to this part of the world, Aspen had dirt streets except for Main Street. That's how far we have come. Carbondale had about 200 people and a sign over the highway saying, "We need a doctor." The Salt was nothing more than an entrance to the Frying Pan Valley where you could go and hide. This was before Lodi. It was before Snowmass. It was before Independence Pass was paved. So we had a very different world. People come here today for the very same reasons that we came then, because it was a special place. It was absolutely beautiful. It allowed opportunities for whatever interest you might have to explore those interests and to protect those interests. And as we grow, and the wildlife, of course, which I'll get to, but as we grew and as we accepted all the people who have chosen to come here, we've become very different communities. All you have to do is go to the community of Carbondale or the Salt or Aspen. Snowmass did not exist at all. My husband did the roads up there, so I know when it was built. My child was 2 years old at the time when that was going to become a series of alpine villages connected with gondolas. If you saw the newspaper the other day and the picture from the hang glider of Snowmass Village, it's quite different from what was envisioned for all of our valleys. We now have 3 or 4 wilderness areas surrounding us that provide opportunity for people to still enjoy that kind of place. Thompson Divide Coalition is formed to protect a very special area that is very close to communities. And it has qualities that reflect all of these needs of all the people. What is important and what is used there and why it's so special and important. And when I look at the map in a minute, you'll see it. But water, of course, is key. I think for all of us, we've talked about the needs to protect our water quality, our water quantity, the needs of our water. The area that you see has incredible water attributes. The Thompson Divide Coalition has just contracted to complete a water study to see the water quality in that area. And I think there were 5 sites that were studied, and the quality of the water is excellent. We know what is in there now. We want to keep it that way. It provides water not only for the fish, cutthroat trout is there, and it's an endangered species right now. And it's water for communities that exist in the 15 watersheds that are there. And it's water for, eventually, for the Crystal and the community of Carbondale and communities below that. There are agricultural permits in this area for the ranchers who are actively ranching today so that their cattle can have grazing areas so that they can grow what they need to keep the cows healthy during the winter and grow it during the summer, and it's protection for open space. That's our ag interest. There are 2 ski areas, whether it's Spring Gulch, which is cross-country area out of Carbondale, or Sunlight, which is a downhill area close to Glenwood, and we have the Sunlight to Powderhorn snowmobile trail, which is widely used. Those are the winter skiing activities that are there. As far as wildlife is concerned, it's prime wildlife characteristics. It involves, and what the DOW, and there's extensive study goes into areas by the Division of Wildlife. The Division of Wildlife has encouraged protection of this area because it is migration route from the northern part to the southern part. It is a calving area. It is habitat, winter habitat. It's essential so that we can keep the groups of animals less separate, which is healthy, and it makes a lot of money from hunting and fishing. It's a hunting and the most prized hunting and fishing area is included in this area. There's mountain biking, there's climbing, there's an incredible geologic formation of the fins, there's horseback riding, dirt biking, hiking, and as far as I'm concerned, it's an area for solitude, which is harder to find. And we all want to provide recreation and the attributes that support recreation, but at the same time do it in a responsible way. And these activities generate acceptable economic and business development. And so the the Thompson Divide Coalition is willing to accept acceptable development while we protect it from inappropriate development that would negatively impact all these activities. We've seen in my part of the county right now, the Crown, for example, which was very valuable habitat for wildlife. And I say was because recreational impacts have pretty much taken away the wildlife attributes that are necessary on the Crown. You've heard Kevin Wright talk about it as a sacrifice area, and to many of us, we don't want any more sacrifice areas. Okay, the maps up here, interrupt any time because I've told you I'm rather nervous at this. These are the counties. There are 5 counties: Pitkin, Mesa, Delta, Garfield.
Yeah, Garfield, let me pull those up. I thought, just for a moment, we can sit them on this chair so some people in the audience can see. We do have a
And the slideshow will show some of that also.
The maps they want to try to...
Okay, we have Pitkin County, Garfield County, Mesa County, Delta County, Gunnison County. Mesa is a small part over here. Delta is down here. The majority of oil and gas leases are in the Garfield, Pitkin, Gunnison area. That's our general map. And we have support from Garfield, Pitkin, and Gunnison counties. We have from Delta County a neutral position. From Mesa County, they chose not to comment or not to take a position because they feel their rules and regulations are sufficient to address the issues that might come about. This shows the watersheds. People have said 15 watersheds. There are 5 major areas in watersheds, but that's the key to the importance of that area for protecting our water and our water quality and quantity. And of course, as you know, oil and gas uses an incredible amount of water. And there are issues about whether the water, when they're done with it, is clean. This shows the oil and gas leases in the Thompson Divide area. Okay. Let me show you the slides. Sure, I can go get those down. Thanks. Okay. This is a map that you just saw showing oil and gas slides. I don't know why it's not more clear, but I don't know how to do that.
No, it's good.
That's the way it is.
That's the way it is. I think that's
Just the way it is.
partially our new projection
Okay,
system.
so there are How many leases?
About 80, I think.
80 approximately leases. Most of them are SG interest leases. I'll get into that in a minute. Well, the leases, according to a representative yesterday, said that the company paid $2 for each lease approximately 20 years ago. And the reason this is important for us to discuss today is that these leases are coming up for renewal. And after that period of time, and you have to do something to renew the leases. And if you don't mind, I'll let you refer to the unitization and that issue after I'm done. And there are wilderness areas in there. There's the issue of gap leases, leases that were given out inappropriately when they were restricted, but they were leased anyway. And we'll talk about the unitization later. It's used, as I mentioned, by the outfitters, by hunting, by fishing, by ag users. This is the total area. The leased land is almost 75,000 acres, federal lands, and that's the area we're talking about. The Piceance Basin is to the northwest, north and west of this area, and another picture will show that. Big game hunting, this is a report I mentioned DOW does a lot of study of all of the areas that it's concerned about. It has done a thorough study of this, and the GMU 4243 are big in terms of economic impact.
So those are game management units?
Game management units, and 42 and 43 are very sought after for deer and elk especially.
And those are an annual
Yes.
number?
Yes. And I have documents that show the money that comes from that. And of course, elk are big, important things. And the difference between a moose and a cow and an elk, it helps. There are bear, there are mountain goats, mountain sheep, I mentioned the cutthroat trout. Cutthroat trout is endangered and it's there.
Go back to that for just 1 second. That is the 5-county area,
Yeah.
and that's the amount of licensing and
Right.
permits and
Right.
guiding direct expenses.
And we were down for a year. They're coming back up on licenses and fees and permits. And then, of course, the outfitters. There are quite a few outfitters in this part of the world that require that. Largest contiguous aspen forest in the United States. It is an absolutely beautiful area. There's Sunlight. It's one of the ski areas. Had 2 leases under Sunlight that I believe BLM, whatever they have to do to negate the leases under Sunlight so that they don't have an oil rig between the ski runs. 4 Mile Park. This is just what it looks like in its natural form. South branch of Thompson Creek. Lake Ridge. Those COC numbers are numbers of leases where an oil rig could be on that site. There's what I'm talking about when I say an oil rig. It could be a location, I guess is the right terminology. COC, Huntsman's Ridge. There's a lease there. Tomahawk Ridge area. There is a lease there. If you've never seen the area, the flights, Eagle Flight has taken several people on flights over the area and is willing to do so, and it's absolutely incredible. Or ride through it, horseback ride, or take a walk. Sunlight Powderhorn. That's Mount Sopris. We in Carbondale would like to maintain Mount Sopris. That's not my topic today, but it could be. If anybody has a question. And the 2 peaks are the same height, so both peaks are named Mount Sopris. There's Eagle Flight.
And that's a
Picture of a lot of roads that we don't want. Roads are not only destructive visibly, but they do a lot of damage to wildlife and wildlife migration and mobility. It's unsafe for animals to be seen on a road, to cross a road, so they hesitate to do that, and you have a lot less interaction. It's a negative thing.
Those are roads to oil or development?
Yes, you see the sites, oil and... Yeah.
See the little pad sites?
Yeah, these...
Yeah.
That's Peon.
Peon's Basin. Rich, valuable oil and gas, I don't deny that. Snowmobile trail, North Thompson Cattlemen Association, it's a cattle grazing area, could be an oil rig in there. And the cattlemen will say in their, it's not a compatible use to have oil rigs and cattle. Usually they've run into some of that in Divide Creek. 15 drainages, that map you saw. Once again, this is, what's this called? Whatever ridge it is, I forgot. Assignation Ridge, thank you. This is a ditch that it provides water to the ranchers, and this just is snow melt generally. And it's, they depend on it and its clarity. It's from 1885, it's an old one. You all are familiar with Jerome Park. We've seen this picture a lot. A lot of it protected by open space and trails. Fortunately, this was probably the first major purchase of Pitkin County Open Space and Trails Board. Thompson Creek, in the back, you see some of the geologic formations there. It looks upside down to me.
It's a side canyon.
All right, whatever it is, side canyon, okay. And the fins. Middle Thompson, cross-country skiing, non-game species, all of those live there. We haven't found the endangered orchid yet, but if we do, I'll be happy. Hayes Creek Falls on the Crystal River, most of you have seen that. The baseline water study, money was raised, grant money was raised. Pitkin County assisted us to do a baseline water quality study in the Thompson Creek and 4 Mile Creek watersheds, and it was tested for all of those things. And the results are the waters are healthy, uncontaminated, and support significant populations of aquatic organisms. Several groups are working now to try to do a study in Coal Basin of Coal Creek to get the same kind of, hopefully, the same kind of information. That, of course, Coal Basin is impacted by the former coal industry. They did sampling of the water in the fall. Just another view. This is, I think, an interesting slide because, if I can see it, how exciting. This is the area we're talking about. This is the larger area surrounded in red. It's Peon's Basin. You see most of the yellow blocks and the other blocks are outside of this area. And that's for a good reason, because most of the easier to get and more abundant development is in Peon's Basin to the west and north of us. This area has other characteristics, and is the reason they haven't been developed in the past is that their studies haven't shown that it's something that we really need to develop, and that all depends on the need and the demand and the cost, and the lack of roads in this area make it more expensive. The inaccessibility because of the geologic structures make it less financially desirable. So that I find that to be a key document. And Pitkin County is well aware of the Wolf Creek storage field. It's in Pitkin County. It's used for storage and gas during the summer months. And it was drilled, I think it was in the 50s, and it did not produce a quantity that was worth developing at that point in time. So it's used for storage. It does provide gas for, depends on who you listen to. Sometimes they say Aspen, sometimes they say Snowmass, but this part of the world, there are sometimes when people in Aspen will say, no, it doesn't provide for us, it just provides for Snowmass. So whatever, this end of the valley gets their gas, and I really don't care where it goes. The Bull Mountain Pipeline, you're all aware of the Bull Mountain Pipeline. This was constructed. Now we're talking about constructing another huge pipeline to Oklahoma so we can get more Canadian oil to Oklahoma. Watch that one too. This is what a drilling operation looks like. If you go to Grand Junction ever, you will see a lot of that. Fracking chemicals are used in the development. We're concerned about these materials. I did want to mention that at a COBRA meeting the other day, I'm told that many represent
That is
Colorado Oil and Gas Association, I think. And the report was that many of the members of the industry said that they are very willing to report what chemicals they use in fracking. They just don't want it to be a requirement, but they're happy to report that, and they are also willing to do testing before and after drilling on the site, but they aren't happy about having that as a requirement either. That's the report that came out of one opportunity. And if you've never been to a site, it's worth the study. Truck traffic is major. This is a scenic byway in the Crystal River Valley. Truck traffic would be detrimental to all that we have fought for the past 25 years to maintain the quality of the West Elk Loop Scenic and Historic Byway that goes to Crested Butte and makes the Lariat Loop. You've all seen that. We have tried to maintain, as one of the unique byways in the state, a byway where we encourage people to get off the byway. It isn't just to drive around and look at the scenery byway. It's get off the byway, find out what there is to do, what is here, what can you do to appreciate the natural environment. Truck traffic would be very detrimental, and the thousands of trucks that are needed, not only during the development phase, but during the maintenance phase, compressor stations, fracking. And this is our mission. The purpose of the Thompson Divide Coalition is to secure permanent protection from oil and gas development on the federal lands, in the Thompson Divide area, including Thompson Creek, 4 Mile Creek, Muddy Basin, and headwaters of East Divide. That's been our mission statement for the 2.5 years we've been in operation. We have support from commissioners, state representatives, congressional representatives. We're working with legislation at this point. And the campaign is to submit and pass legislation for withdrawal of leasing on the Thompson Divide area federal lands, referred to as the Thompson Divide Withdrawal and Protection Act. This draft legislation was presented to John Salazar when he was in office as our representative, and before it was able to move forward, he was replaced by Scott Tipton as our representative. So we are now backed up a little bit and educating his staff and him with regard to what we need to do. We, Thompson Divide, hope to have a meeting with Scott Tipton in September, after his schedule permits it, to talk about what we need and what we want to do in terms of protecting this land. And we have been in touch with Senator Bennett's staff, and Senator Udall is also aware of what we're doing, and Udall and Bennett have agreed that Bennett will take the lead on this in the Senate office, with Tipton taking the lead on the issue, but as our representative. We want to go through the representative information first, because he represents us, and then would work with the Senate to do this. Our plan is that once legislation is introduced, that the industry will be more accessible, shall I say. TDC has always made it open to industry to come meet with us, come talk to us. And we have had some discussion with them, but there's no pressure for them to meet with us. And I think my personal viewpoint now is that once we have legislation proposed, rather than discussed, that the industry will say, okay, let's talk about what we can do. And we'll talk to the leaseholders at the time. These live up Thompson Creek. They have young every 2 years. And this was one year when somebody got a fantastic picture of our great horned owls. And we're sitting there quietly waiting for something to happen. There's the end. As we are, aren't we all? Thank you. Any comments, questions? Or, let's see. One thing I think is very interesting, I'm going to jump now a little bit, but I hope some of you saw in the Denver Post an article that says the deer and antelope populations in Colorado's northern mountain valleys have declined sharply, 40 to 60%. Colorado Division of Wildlife officials confirmed declines in the area from Medicine Bow Range west to Vermilion Bluffs, north of Moffett County. We don't know why they're declining, but this is in an area of intensive oil and gas development. So this study that's being promoted is to find out, is there a connection? If so, what is it? We have a fact sheet that we'll leave with you that Sonoran put together with a lot of different Colorado economic facts that show the impact from hunting, fishing, outdoor recreation, parks, public lands, tourism, wildlife watching, which sometimes brings in more money in an area than hunting and fishing, agriculture, and just protecting the landscape. We'll leave this with you, but it talks about the millions of dollars that come into the area because these activities can occur.
And Dorothea, that's very specific to Thompson Divide.
No. This is land conservation in Colorado. But it gives you an idea of the impact. And I think you've seen in this updated book that we'll leave here, which it shows impacts in the area from oil and of economic impact of the visual wildlife in Thompson Creek is in this. So it is significant. Okay.
So you asked for questions?
Yeah.
Are you done with your presentation?
Hold on 1 second. Okay. We've talked about that. Yeah.
Oh, good, thanks. First, Rachel, I just wanted to recognize and welcome. We've got staff liaison from Representative Tipton's office, Brian.
Thank you.
Hi, Mark.
Thank you for being here.
Absolutely.
Some of these pictures that you showed us in where there's potential for leasing to occur on public lands, they are currently in roadless areas.
Some are.
Some are, and so it's a little interesting because what's happening concurrently right now is that the U.S. Forest Service and the Colorado Department of Natural Resources are in the process of going through all the public comments regarding the new proposed Colorado Roadless Rule Act. And of course, this area is the largest contiguous roadless area in the state right now, about 22,000 acres. And I've been playing phone tag with Bob Brando, who's the director for the Department of Natural Resources, and they understand the concerns that we have in terms of looking at changing with the proposed roadless rule from the original act, which was 2001, and specifically we were asking them not to make any changes until they really start to address the gap lease issues. And that's something that they can do within the new roadless proposed act, or they can take immediate administrative action. And I think that's a really important part of this whole discussion, because that may or may not provide the opportunity to open up a lot of these areas that should have been designated and currently are designated as roadless to maintain that status, which would protect all the attributes that you have said in your presentation. So I think that's an important part of this that I hope that you'll pass on to Representative Tipton, that this is a critical area for roadless terrain, and the proposed new rules should take that into account when we start to look at these gap leases. But Dorothea, one question I have for you is, when you started your presentation, you said that the Thompson Creek Coalition is looking at the opportunity to work with our representatives and to find acceptable development. And so what is the coalition looking at when you mention that acceptable development in this area?
What currently occurs.
What currently occurs. Okay. So no new additional
Correct.
Permits and allowing those leases that are to expire to let them expire and not re-permit them. Exactly. And again, this is all just on federal lands, not on private lands.
Correct.
Thank you.
And Do you have any questions, or?
No.
Okay, Peter was going to talk about the unitization concern that we have. Is that appropriate?
that'd be fine.
Right now?
Can I sit here?
Sure, you can sit right there.
Oh, you want me to sit in the hot seat, huh?
Yeah.
And just introduce yourself to the cameras, Peter.
Okay. My name is Peter Miller. I'm a staff attorney at the Wilderness Workshop, and I've been working with the Thompson Divide Coalition for 2 years, trying to work through a lot of the public land issues involved with their mission. In April, SG Interests filed a unit proposal for 32,000 acres in the middle of the Thompson Divide. So it's a big thing. We've seen one other APD filed in the Thompson Divide.
APD?
Application for permit to drill. And that was filed by Antero in the Lava Boulder area, kind of over on the east of I Creek side. But this unit proposal is 32,000 acres that basically slices right down the middle of the Thompson Divide. And a unit proposal, for those who don't know, basically effectively groups together a bunch of leases and then allows for a long-term development plan of those leases. So one of the effects of it is that as long as the terms of the unit plan, the unit agreement, are being complied with, it extends the terms of those leases. In this case, the 32,000 acres includes 18 leases, 16 of which are owned by SG Interests, and I think 13 or 14 of those are leases that were issued in roadless areas after the 2001 rule was implemented, and many of those, I'm not sure what exactly the number is, don't have no surface occupancy stipulations on them, which means that in conflict with the 2001 rule, the operator could potentially build roads on those leases. So one of our big problems is that a lot of these leases in a proposed unit are of questionable legality to begin with. The other problem, of course, is that the unit would essentially have the effect of extending the terms of these leases well into the future. That side, there's a flip side to unitization. I mean, a unit proposal is intended to ensure orderly development of a bunch of oil and gas leases. The idea behind a unit is that it's going to make it easier to get all of the resources that are underground, and it's going to make it it's going to allow the operator to actually pursue development in a way that makes economic and environmental sense. So in this case, unitization, there are generally benefits to unitization. The idea is it's probably a good policy. The problem is we're dealing with a potential unit proposal in an area that a lot of people don't believe is appropriate for oil and gas development. And we're also dealing with a number of leases that we believe shouldn't have been issued as they were in the first place. I noticed that Jerry Strahan and Steve Bennett are here from the BLM, so they're obviously probably more expert on unitization than I am. But I will say that prior to approving or designating a unit, actually it's approving a unit proposal, the BLM has to make two threshold determinations. First, they have to decide whether that exploratory unit is necessary and advisable in the public interest. And our argument in this case is that it's clearly not. There are thousands of people in the Colorado River Valley and the Roaring Fork Valley and the Crystal River Valley and the North Fork Valley who have all joined the Thompson Divide Coalition and said that this is an area that's inappropriate for oil and gas development. And then the second determination that they have to make is whether that unit agreement or proposal will properly conserve natural resources. And that obviously is more of a, at least initially, you'd think that's more of a geological determination, more of a technical determination. And it is to a large extent, but I think it's important to take into consideration case law interpreting that term of art, that phrase, properly conserve natural resources, basically saying that the agency has to consider not only the geologic resource, but also those natural resources above ground in the area, water quality, wildlife habitat, recreational value, all of those other natural resources that Dorothea just talked about. So in this case, because of the critical values, natural resource values that exist in the Thompson Divide, we've got a pretty good argument that that natural gas development may not be the best way to properly conserve natural resources.
Peter, I'm not as fast on taking my notes. What was the first threshold question?
Whether a unit is necessary and advisable in the public interest.
I want to comment just briefly. I see the two representatives. Steve Bennett is here also from the BLM. In the 2 years or so, and with my 12 years on this board, with CCI, my thrust, my interest has always been working legislatively to resolve issues. I've made that very clear to everyone. And I just want to point out that in working with the BLM locally and the letters that we've sent out of local, they've been most cooperative, most willing to listen to a position, and I want to commend them for their willingness to see that there are more than one side to a lot of issues. And they have been very good to work with. I've also worked with the Forest Service, and of course they have the surface needs. And the DOW owns land in many cases where DOW doesn't own mineral rights on that land, but has to work with the oil and gas companies to make sure operations, if they do occur in an appropriate way to best maintain the wildlife considerations. So I've worked on those issues, and I just want to point out that people with whom I've worked have been most cooperative, and I just wanted to point that out. This is not a battle that we're in. We're in an issue of we've got to find the best way to address this for all of us. And there are so many people who believe that what I explained from Thompson Divide, which protect this unique special area, are doing it for the best interests of the people who live there.
Thank you. Dorothea, did you have other components of your presentation for us today?
Other than answering questions, I don't think so. My final little comment would be this. We're talking about inappropriate development versus responsible development. It's something you deal with every single time you see an application. And I think we have in this valley unique local involvement, local control. People are not afraid to say what they think should happen. The fact that 250 people showed up at Senator Bennett's meeting yesterday, I think shows people are very concerned. The county has certain things that it can do. I know you're dealing with regulations for oil and gas development. And while certainly we all understand that the lack of importance in some cases of that, thank you very much, but we're going to do what we want to do anyway. I mean, for those of us who live here, it is very important that we hold development of any kind, which includes industry and oil and gas, to meet the requirements and standards demanded by the people who live here. And I think Thompson Divide has been very careful to get support from grassroots support, from retail shops, from agencies, from congressmen, from senators, from representatives to say this is important for a concern. And we really appreciate the involvement of Pitkin County in doing this and in all of these and being interested enough to that talk is big. Thank you very much.
Thank you. Dorothea, do you know the magnitude of the agricultural cattle grazing leases in that area? Is it?
Do you know the number?
There are 13 federal grazing permittees in the area, but I'm not sure what kind of revenue is generated from those operations.
Well, I was thinking more the acreage or the size, but 13 large leases.
Yeah, I mean, if you look at, we actually have a map someplace that overlays grazing permits with the Thompson Divide area, and it's predominantly all grazing permits.
It's major.
It's all allotments.
Yeah,
It is.
And
Yeah.
and I think the other thing to think about when you're talking about grazing operations is just the impact that that those operations have on open space on the valley floors. I mean, I think that's, and, what we've heard from...
There are two cattlemen's associations, I believe, right, that operate in that area.
The North Thompson.
North Thompson and...
John?
We do have Jerry Strahan from the Bureau of Land Management. While we did not ask for a formal presentation or such, he expressed some willingness to maybe just give a high-level overview of the unitization process and that decision-making process. I know that's something that we've been asking about, and it may be an appropriate time, since we're at this point in the discussion, to invite Jerry up. And thank you, Jerry, on short notice for giving us a high-level overview from the BLM's perspective of the process, so we understand the touch points and such.
Thanks for inviting me up, and I just want to say, first off, that I thought Dorothea's and Peter's presentation were some of the most balanced and accurate ones I've seen, so I really appreciate that.
Thank you.
I think Peter really explained the process. He didn't explain the process, but he explained the goals fairly well, so that was good. From our standpoint, my staff processes unit agreements. There's, last time I checked, there's 178 in the state. They're fairly common. They go back, clear back to the first wells in Pennsylvania. And the idea was to get that orderly development as opposed to, first in, first one gets it. So it's evolved over time as a way to logically develop an area. And as you commissioners have staff, I'm a staff member for the Bureau of Land Management, and I've got regulations and rules that I have to follow. And that's what we do. We take the current situation, there's a lot of points about the leases and the roadless area and everything. We have to deal with what, our lawyers and what the current situation is. So company makes a submission. We review it. We have a geologist and a petroleum engineer that look at it and review it. We take a look at the ownership within the unit. Unitization is 100% voluntary. We don't go out and ask people to join the unit. The people that are within the boundary that is chosen come to us and say, we would like to unitize. We would like to bring these leases together. Again, most of the time it's for the purpose of making the development more economical and more sure. For example, in an area like that, we don't really know the whole potential. We wouldn't want to drill a well out in the middle of it and not have a pipeline to produce it. So a unit might allow you to start on one side of the development area and work your way out so that your infrastructure, your roads, your pipelines and things like that would go with it. So when we're looking at the unit, we look at that ownership. You have to have at least 85% of the leaseholders in the unit in order for us to move forward on the designation. As Peter said, we look at the geology, and we have some knowledge of the geology in the area. Obviously, the companies that have drilled in this area have quite a bit more knowledge on geology. And no offense to the geologists if there's any in the room, but two geologists can bring you proposals and you'll get 3 or 4 different ideas about what's going on out there. So we don't try and judge between different proposals. If the company brings a proposal and says the structure is that and they want to test it, that's what a unit's about. The public interest portion of units that has to be met is the drilling of a well. The public interest portion of unitization is specified in regulations. And it's in order to complete the unit and have the unit continue, you have to drill well and it has to produce. It has to pay royalties to the state and the federal government. If you don't drill a producing well, then the public interest is not met and the unit goes away. It also sets up a time frame for development. If you have a producing well, it sets up a certain time frame before you drill your next well. If you have a non-producing well, then it sets up a more strict time frame. You have to continue to develop. Now, none of that is any different than what you have on the lease terms. Lease terms also have requirements to be developed in a timely manner. Congress, when they set this up, they did not want to have speculation on oil and gas leases, so they set a diligence provision in each lease. If you don't drill, and many of these are not drilled, then that's why the leases go away at the end of that 10-year time period. A unit is the same way, except it's actually a little bit stricter. Once you start producing, you have to continue to produce, or the unit shrinks down. Any leases that you don't drill and produce, they fall out automatically. So that's basically how we look at it. It's when a proposal comes in, we look at it from a technical and geological method. We make sure that you have all of the owners in there want to participate, and it's got to be at least 85%. People don't have to participate if they don't want to, but you can't have a unit with less than 85% participation. We require a plan of development that shows where they're going to drill and what their process is. That's part of it. And then we review that, and there's some give and take on administrative boundaries, or if there's a difference of opinion on geologic areas. There could be people that drop out. The boundaries change in and out depending on what those discussions yield. A unit is then designated. Then at that point, the operator needs to prove to us that they have that participation. They have to come back in with letters from all the people that are in it and proving that they want to join the unit. And then the next step is approval.
And where are you in the process?
On this one right now, we've got 7 unit applications in right now, and I checked with my staff. We really haven't even looked at this one. We've had the meeting with SG, which is called the Area and Depth Meeting. That's the first meeting where they come in and make a proposal. And basically, I'm a little short-staffed right now, and my staff are working on other things. So we have not made a designation on it. We haven't done much other than that initial Area and Depth Meeting.
Let me start with a few other questions, and
Sure.
I greatly appreciate you being here today. Is there a portion of this process for public comment or concerns from county commissioners and other regulatory bodies in the region?
Well, this is a fairly new thing for people to want to comment on a unit proposal. There isn't really a specific part in it, but what we've been doing is taking comments on it. If people have been commenting on it, we've been taking those comments, adding them to the case file, looking at what people are saying, and accepting them in that fashion. Units are, as I said, are just an administrative action. There's no change in what's already been permitted, because you're taking existing leases that have already had their NEPA done and all the inspection and everything that was done previously. All a unit does is it's a piece of paper that just says we're going to treat those all as one lease, essentially, from now on. So units are categorically excluded from further analysis in NEPA, and like I said, we accept comments on everything, and I appreciate what you said about working with you. That was fairly nice thing.
It's been a very nice situation.
We're always willing to talk to people. I know I've talked to Peter a couple times, and we've met actually with Jock and the rest of the coalition up at the state office.
And then to kind of follow up on that, you can take comments, but they're not required, and the various standards that you need to look at, what I'm wondering is, do the other economies, the potential to damage the other economies of a region, considered at all when you are looking at the advisable for the public interest?
That's already been done at the leasing and APD stage. So again, at the unitization stage, there's really no need to do that. It doesn't.
Who does that?
It doesn't have any effect.
So when they were leased back as gap leases, kind of counter to the roadless road. I think that's where a lot of people feel a little left out in the dark in this one, because there was a perception that this area was part of the roadless rule, so there would be no leasing of it, and then the next thing, there is a lease auction of areas that the general public perceived to have some level of protection already.
Yeah, I wasn't part of that. I don't know what went on during that time, and I've heard a lot of pros and cons about that. But, Steve, were you involved in any of that? I mean,
No, I wasn't.
okay, so,
You know, it involves the National Forest
Please
land.
come on up, Steve, so cameras can get you out of the shadows. Introduce yourself, we appreciate that.
Steve Bennett, field manager at the Colorado River Valley Field Office in Silt, down mountain here.
Yeah.
But the leasing occurred under the Forest Service's planning process. It's primarily affecting national forest land, so they will recommend to us, as we consult with them before we do a lease sale, they'll recommend whether something should be leased and under what terms and conditions it should be leased. So I'm not sure actually what transpired at that time either, as far as the roadless rule.
Would there be any documentation at the time those leases were issued that we could access that, talked about what work was done to evaluate the wildlife needs and the other needs of the area? I mean, again, it just seemed, at least from my memory, and that's starting to slip a little bit these days, is that, you just kind of read in the paper one day that all these are up for lease sale, and again, there seemed to be very little public involvement or notice that.
well, I'm sure that analysis was done, but it would have been done by the Forest Service.
Okay, so the Forest Service could hold on to that. And then,
Well, we would probably have the record.
Well, we should have
Have
it.
our record of, that lease sale.
Right.
and I'll ask just one last question, because I'm just, and I could be mixing and matching between your comments, but you had said that the unitization then acts as one big lease, but it doesn't put in any new provisions about how the drilling will occur or how the roads will be built or anything like that. So it kind of takes whatever was done as the old work and combines it into one, but this is supposed to make it more logical and economical, but it doesn't necessarily then create logical or economical advantages for the other industries, the other
Right.
needs of the community.
Well, we never direct a company how to develop a lease. I mean, they bring a proposal in, and then that's reviewed. What unitization allows is for them to bring in a proposal that includes that logical development. Instead of drilling a well here and a well there and a well here and a well there, they can bring in a proposal now because of unitization that might drill a well here and then work their way out there slowly. Just as an example. Now, under the lease terms, they need to drill a well in each and every lease before the end of the 10-year term.
And how long does a unitization, you talked about timelines within it, is it basically a 10-year extension of these current leases for them to begin that drilling and logical development?
Well, the underlying authority is the lease still, but what happens with the unit, as long as a company drills and produces and pays royalty, then the unit will continue. The continuum must, the development must continue in order for the unit to stay the original size. If they don't do what they say they do, then the unit contracts and the leases go back to their own individual terms. And what that could mean, and what it does mean often, is that a company will drill a few wells, they'll have a few producers, the price of gas might go down, and they'll stop drilling. Well, what automatically happens then is the unit contracts back down to the area where it's producing, and those leases have to stand on their own. And if they expire in the meantime, they're given 2 years to proceed on their own, and then they would expire also.
Okay. And I also just want to be clear for myself. You have either kind of a thumbs up or thumbs down authority on the unitization request. So you can't say, well, this proposal could be acceptable if there was no surface occupancy, but since you didn't propose that, we're going to say no. So there's no modification, there's no negotiation of what would be an acceptable unitization request.
Well, the occupancy and those sorts of things are done at the leasing stage and the APD stage. So the unitization approval is kind of bracketed by those two things. A lot of analysis is done at the leasing stage, and then the other might be unitized in the middle. Again, just an administrative action. All we're doing is saying that for our consideration, we'll treat all those as one, but they still have to submit an APD, and that APD is subject to a full NEPA review, public comment of 30 days, and all of those sorts of things.
Okay.
So it kind of fits between the analysis of those two.
I see our community development director has a question back there, I think, and then I'll come back to you.
Thanks, hi, I'm Cindy Goodman, Community Development Director. I'm just a little confused about I think what Rachel's getting at are the stipulations that are in either the BLM or the Forest Service.
Right, those are part of the lease and the APD.
So there's no opportunity at a unitization stage to incite new stipulations
That's
either
correct.
at the surface or at because you're developing a plan, they're submitting a plan for an orderly development of the site. And I think what Rachel was saying is that might kick in another way of looking at it that might preserve other resources. And I know that both BLM and Forest Service have surface stipulations, and BLM has surface plan review on the surface stipulations. But so
I think what you're thinking about is like our master development plans, where they bring in a proposal for an entire area, and they've got all of the wells, I guess, kind of staked out essentially.
yeah, I know about that. But
Right.
so a unitization, is it similar to that?
No, because one of the things about unitization is that they're, at least this one, they're exploratory in nature. They don't really know what's out there yet. So they're not going to propose, tons and tons of wells. The approval is based on either drilling one or two wells and seeing if we get production out of those. And if they don't get production, they can then choose to drill additional wells, or the unit will contract and go away.
But that's where I'm confused, because I thought I heard you say that if they don't proceed and there's not a well on every lease within the unit, then that can go away. And I was confused by that.
No. The unit makes the whole thing like one lease.
Okay, so there's only one well.
There can be only one well.
So that's where I was
correct.
confused,
Yes.
because I thought you had said that all wells would have to be drilled.
So when they're the individual lease terms, you have to drill a well on each lease in order to hold the lease.
When it's outside.
When it's outside the unit,
Right, but you only need one well for a unit.
to start with.
But then you must keep proceeding.
You must keep going. It depends on what the results of that well are. Did that help?
I think so. I'm also wondering about the BLM management plan at this point and where that lives, I know we've been working on it forever.
Right.
And is there any provision within that plan, since I know that we've been working on that as review agencies and partners on it? And is there any type of provision that would say, like our master plans, and that would, an area that it would be premature for a decision based on the fact that we're still in the process of development of that plan and the areas of, environmental, you call them AC. Areas of critical environmental concern. And I know that this Thompson Creek area has definitely been looked at as that, and it was considered actually for the wild and scenic river status, but then was pulled back on that because it was just a small portion that didn't qualify from a water resource perspective on that. So I'm just wondering, is there any provision, since the master plan has unfortunately had to stall out for various reasons, if there's any provision that you would say, well, it's kind of premature for an understanding about the unitization or proceeding with these gap lease type arrangements when in fact we haven't been able to proceed with the management plan? Is that anything that
Can we use that?
Yeah, does that work in the world?
I mean, we're on track right now to release the draft RMP, Resource Management Plan, in September. So we've finally
A year from when we
freed up
thought,
from
yeah.
some of the things that were holding us up. But so it's on schedule to go out and start the 90-day public review about September 16th is what we're working towards right now. So we're close to getting it out. But you know what we have considered and do during a draft RMP stage is we will potentially defer leasing. You know, to not forego options in the plan. You know, if we're looking at different options and
Right.
potentially no lease or something like that, we would, you know, we've certainly done that. But I don't think there's ever been a case where we've not worked on a unit or deferred action on a unit because we're in the middle of the resource management plan process.
How about the gap status? Does that play in all of that? Because
As far as a master development plan? or-
since it's kind of an unresolved
Oh.
legal issue.
Well, again, you're talking about national forest plan, so our resource management plan, again, doesn't apply to the forest.
But it does apply to the resources under that.
Well,
On the
like
gap.
in the BLM resource management plan, we're not going to make decisions on leasing in the national forest. That, again, is their decision as far as whether they want to make lands available and under what terms and conditions. Now, they're also close to releasing a supplemental oil and gas EIS, environmental impact statement, and that could go out in about the same time as our RFP is going out publicly. But that's where they're going to be looking at new terms and conditions and whether which portions of the forest would be open or closed to leasing in that document and stuff.
So it still didn't answer my one question. And maybe I'm just confused about the ownership there, but it seems to me in the Thompson Divide area that it's forest surface and it's BLM
Right.
mineral.
Right.
So with the gap leases, it's BLM mineral. So wouldn't you want to hold off on your decision about that? And then that would logically lead to the decision about unitization because you haven't gotten to the master plan provisions.
I guess I would say the decision's been made, as far as we're concerned. The leases have been let, the Forest Service told us to go ahead and lease them, the environmental work was done. It would be, we're not allowed, I mean, as staff, we're not allowed to speculate on what the outcome of lawsuits and things would be. We have to work on what is now. And I guess I would look at that, if I lease a car and somebody comes and says, well, you can't drive that car on a dirt road, I would say, well, was that in the original lease terms? And I'm just trying to think in terms, I put myself in the company's shoes and say, you know, we leased this under these terms and conditions, we signed a contract, and from my staff and our perspective, we have to abide by that. We can't go outside our regulations and speculate on what might happen in the future. We have to go on the decisions that were made.
But I'll drop this, but just the one question is that's true, and I understand that for your leases, but how about for the unitization decisions?
Well, and the unitization is based on the terms of the lease. All of the ability to unitize is built into almost all oil and gas leases, whether they're federal or private leases. They almost always have that built into them, and it's considered in the public interest to unitize. It conserves the resources. So
But it also,
it doesn't allow us to go back and revisit earlier decisions, though. We only can look at the decision of whether or not the proposal meets the requirements.
and do you not feel that the unionization gives any further rights to the people enjoying that unionization than the individual leases?
Well, I think it gives them certain rights, but
That's-
it doesn't give them anything that they don't have in their lease. That's the key. There's no change. They have to drill, they have to develop, or it goes away.
I I see George's hand is up. I think that a part of maybe the concern is that some of these leases are naturally expiring, and maybe they would even be reissued, or they'd be put up for bid again. There would be a potential that there would be more thorough terms and conditions placed on the lease.
This is really a good point, because we work for the public. There's other public. This point is that the leases could expire and go away completely. That's one point of view, certainly. But I have other publics calling in and saying, why don't you let those leases expire, because they would go for millions of dollars next time. They wouldn't be leased for $2 an acre. We're getting leases now for thousands of dollars an acre. And that money goes to the public, half goes to the state. So I have other people that are coming and saying, why don't you let them expire so that we can release them? That's why we don't work from opinions. We don't work here. We work out of our regulations, and that's why we follow our regulations. We don't want to have that power, that authority to make decisions that affect people's lives and all those things. We want to follow our regulations and follow the guidance that we have.
Yeah. And we're just trying to sort through it, both for ourselves and the public. You have built a career around understanding the interplay of these different agencies and rules.
Yeah, we could drive ourselves crazy with all of the different interests and on each and every issue. This one has a lot of people interested in it, obviously. And I know the Thompson Creek area. I love it. It's a beautiful area. I mine coal in there. I worked at the 2 coal mines that were in there, so I have a direct knowledge of the economic impact of the minerals in there. That's been a long time ago, but it's a beautiful, beautiful area. I think it's great.
George, you?
If I can remember now. As we're talking about the unitization, at this point, has a BLM permitted SG for the utilization?
Yeah, lessee. Right.
Have you already given them the permit?
For the unit? No. We've had the original meeting. We have not worked on it any further since then.
So,
because we have other unit proposals that came in first, so we have to work on them sequentially.
So, just back to some earlier comments, it seems that it would make more sense to hold off on that, given all of the work that is being done in terms of trying to protect this area, specifically the Thompson Creek area, vis-a-vis our Congress, our senators, and rather than open up the door to unitization, which may lead to infrastructure, roads, pipelines, it seems to me that we should wait till we are able to work with Senator Bennett.
If I've given the impression that unitization causes all that, I want to make this clear. That could all happen right now. The lessee has the right to go in and drill the wells and build the pipelines and do all that stuff now, at least to apply to do that. Unitization doesn't have anything to do with that. And then the second part of that is that I sure don't have the authority to do something like that if the secretary or somebody like that was to tell us. Certainly, I work for them. But that's way beyond my authority to, purposefully hold up, a submitted permit. We have our regulations and our instructions, and just like your staff does.
Oh, sure.
And, I'm sure you expect your staff to continue to handle things until you give them other direction, and that's what my staff will do, is we'll continue to process things until we're given different directions.
So what I'm hearing you say is we need to work more closely with our congressional delegation to ask them to put a delay on this approval until we're able to perhaps come to some sort of resolution in terms of the future use of this area.
I certainly think that's a better avenue than asking me. It's beyond my ability to do.
Thank you.
Jack, we're going to take a few comments for the board, and then we'll come back to the people who are participants in the conversation.
Yeah, this is a very appropriate meeting, timely also. Appreciate the Thompson Divide Coalition in my parts of 4 decades being involved in environmental community issues, never seen such a wonderful compilation of a coalition of diverse groups of people that are represented. And this is September 29, 2010, so I don't know what has evolved since then as far as other support, etc. But this is, it's just amazing, and I hope the representatives team has these kind of documents. That's what, so something's evolved even further. It's great. But, and I want to thank Brian. Appreciate very much you being here.
Absolutely.
Obviously, Steve, and I apologize, sir, I didn't get your name.
Jerry.
The BLM, environmental groups, etc., interested members of the public. This issue of unitization, I understand rules and regulations, and you're absolutely right. Our staff, we live within the context of those rules also. But we hope that your decision in the direction that George just kind of plowed through here is very positive. But we hope your decision in this request is not looked at for unitization in a vacuum, because there's a real problem in my mind about the timeliness of this request, because these leases are ready to expire. I should say many of them. And it seems like an end run about, well, okay, so they expire, but right at the same time we have a request that really is a delay tactic. This is my definition. We can look at it and define it in any way you want. But this is not an issue that can be made in a vacuum, and we can't rely just on rules and regulations, so that's your job. You represent the public, and the public is very, very interested in what is happening in this area. State of Colorado, there are just thousands upon thousands of leases. It's not like we have a national challenge about access to leases and drilling and supply for natural gas. In addition, and we've heard some of this, but and I make no apologies to bring up a couple things. The Forest Service, as we know, is doing their draft EIS. That's about to come up. Steve, you certainly just gave us a little more certainty about soon, hopefully, your resource management plan is coming. And then those of us on the environmental side, and if we just look at that box, we're really concerned about this gap issue in the 2001 roadless rule, etc. All these things are happening all at the same time. And I am really glad the timing is such that you have multiple requests for unitization ahead of this, because maybe we can have the time to do the things we need to do on the outside, as it were, because we understand and respect absolutely what you all do in the Forest Service. And I think, Steve, we've had multiple meetings. We pride ourselves as a county organization to be involved regionally, and as well as statewide and nationally, and we want a good outcome. And the real positive about the Thompson Divide Coalition is you can't call them outside of the box radical environmentalists, etc. There is a diverse group here that, again, I repeat, I've never seen such a fantastic group of interested parties, from local government to the ranching community, etc. So I guess my closing comment would be an appeal to Brian and Representative Tipton. He was elected to represent all of us. We understand politics, but this issue is actually beyond politics. This is about the heart of the community and about the land, the resources, and the interaction of people with the land. And we would like Representative Tipton to step up to the plate and show leadership here and represent the interests of all of us, because it's not just the Pickton County Commissioners, as this said. It's not just the people who live in the Thompson Divide area. It's not our friends from the BLM who have serious challenges all the time because you're under the gun. You know, the bullseye is over here as well as over here and, of course, here. So we would sincerely appreciate an in-depth look at, analysis, and then support for this issue. We need the representative to carry this legislation, and it appears certainly that Senator Bennett has indicated that he'll carry his ball. So as a team, we can get this done. And no one's saying, no, nothing can never happen here, but no, let's do this in a sensitive, resource-oriented manner that we all can come out winners. So, Brian, please take that message. Absolutely.
Thank you. Robert?
Yeah, you know, I think as Jack says, this comes to the heart of a community, but I also think it comes to the heart of a economic vibrancy here in our community. You know, as the Thompson Divide Coalition showed in their presentation, and I believe very strongly, we cannot for an instant underestimate the value of the natural resources on our tourism economy, our local visitors, our, you know, the money that they get from the hunting licenses, the fishing licenses, all of that. And once it's gone, it's gone. I think we should be working towards seeing a resolution before unitization happens. But more so, I think what troubles me that I learned through this dialogue is that the unitization doesn't have any additional triggers for reevaluating the original leases. And I think that's really what needs to happen in legislation down the road, which is, as a unitization happens, the leaseholders gain a benefit by being able to use economies of scale to develop certain lands. Well, the natural resources that we all appreciate in having the surface land keep in a natural state needs to be protected and should be re-evaluated at that point. So I think that's something that we should look at, moving towards some sort of re-evaluation as a unitization process happens. Now, I understand, you know, as you've stated, you're under regulations to follow your guidelines as it is today with those current leaseholders and protecting their rights. I believe in that too. I mean, you have contracts with them, and I believe there's an aspect to that. And you're doing your job, and it sounds like you're doing your job very well. But I think we as public officials need to work towards some new legislation on how that happens, specifically in areas like this. You know, it's not an appropriate place for this sort of development, given how, you know, myself as a business owner in this community, how we depend on that sort of people coming to this community. I mean, once it's gone, it's gone. I can't stress enough how we cannot undervalue what that really means. And that's changing all the time, which leads towards this reevaluation of how valuable that is, not just when the lease is given, but maybe those leases should have trigger reevaluations of that. So, I mean, it seems like we've got a lot of things to push forward and push Representative Tipton towards and our other representatives and those sorts of things. This is a big part of our community, and this is what we want to protect.
Yeah, Dorothy, I see your hand up as a coalition rep.
Yeah, I just wanted to point out that Scott Tipton, Representative Tipton, has agreed in September, and we don't know the date yet. Mike Hess, I'm sorry I didn't recognize who you were before, or I wrote back. Mike Hess has said that in September sometime we will know when Scott Tipton is going to be available to have a meeting with TDC, and we'll certainly let the commissioners know when that occurs, and this is to discuss further options. And I don't know that I made it clear, there's a draft bill that you've all seen, but that's what staffs, and our understanding is that staff for Senator Bennett and staff for Representative Tipton are currently having discussions and working together on next steps, and certainly after the meeting with Representative Tipton, we hope that will move forward in a more comprehensive way. That was all I wanted to add on.
I wanted to ask one question that I didn't entirely understand. And as everyone else has said, we greatly appreciate you being here today. It helps our knowledge, it helps the public's knowledge of what's going on, and sometimes the lack of knowledge creates more fear than necessary. But you said that once leases have received their permit, their drill permit, they're categorically excluded from NEPA. You said, I just heard the category exclusion from NEPA process in your comments, and I wasn't sure if that all the way clear.
I definitely better clear that up.
Okay.
What I was saying is that the approval for unitization is categorically excluded from further analysis under NEPA. Just the approval of unitization. And again, that's just the grouping together of the paperwork and saying that all of these leases are in this unit. That's the only action that I'm talking about there. Okay. The NPD is not categorically excluded. The leasing is not categorically excluded. I probably do this too much. I make a lot of parallel assumptions. But it's like if a BLM person gets a raise, that is technically subject to NEPA. But we don't actually have to do a NEPA document because it's categorically excluded.
Okay.
So that's the level, and I want to assure you guys, there's hundreds of those that occur a day. Those types of little actions where you're signing a piece of paper and you're maybe changing something in a computer and saying, well, these leases group together, or Steve gets a raise, or whatever. And those things, we are required to do NEPA on all of those, except when they're categorically excluded, which is still doing NEPA. So that's where I'm at.
Yeah, thank you. I appreciate that clearing up. I think others have said it very eloquently, but there is a lot of concern in our community about the potential damage to other industries, other major economic drivers in our community. And Pickens County residents have chosen to tax themselves for a pretty aggressive open space and trails program. And we've invested a lot of that money in the Crystal River Valley. So whether it's the Coal Mountain Ranch, who need to use these lease areas to keep their agriculture going, their ranching, their cattle, that's been a real deliberate decision to try to keep these type of industries for our heritage as Coloradans going. And so we hate to put the money into the financial support on the bottom land and then lose the value of the summer grazing land that would support that. We've put a lot of money in open space and conservation easements in Jerome Park, up the Crystal, any number of little teeny pieces that have been preserved that have, and more on our docket if we're so successful, that are a response to that community's very unique desire to maintain their character. And so there have been those type of investments that have been very important. And we also see fairly regularly the different reports that are out there about the impacts in other areas that have experienced a higher level and an intensity of development in oil and gas. And those are concerns. And we haven't really even talked about the airshed. But when people choose to come out here to go skiing, we may think that this area is a million miles away, and they may not drive down and look at it, but the air quality and the airshed is very important. And so just reading myself about some of the issues, I think it's with hydrogen sulfide that's been found in the I-70 corridor regions in a number of the leases. And I think we all kind of notice it when we drive through anyhow, that there's just a very distinct different odor. And so, you just don't get elite athletes wanting to come to 9,000, 10,000 feet to do a big race and have an underlying issue with air quality in that area. They just don't expose their lungs to that. And there was, time periods where every agencies had issues, but there were the dark days at BLM in the leasing office in Denver, and the unnecessary fraternization between some staff, before the change of office in 2008 with industry, and that was all pretty well documented. And it was our concern that a lot of these gap leases were issued during that time period and under that sort of influence. And so that's awkward to have to bring up. But the legitimacy of those leases and what level of real documentation and public comment and review of these areas before they were leased, and that kind of indeterminate legal status, I guess, is what I would say. They have been challenged that they were inappropriately issued in a roadless area, the largest contiguous roadless area in Colorado. And so what my concern has been, and this is clearly in layperson's term, is that the unitization will give a new shade of legitimacy to leases that are in dispute and will extend them out from naturally expiring. Because we have participated with the Forest Service and in their scoping comments for their new plans, and while they are under their own set of mandates, it's really clear we would like to see these leases expire and not be released at all, and that many of them were probably not legitimate leases in the first place, given the kind of clouds that have been over that process. So again, realizing that you're in a difficult situation and that federal legislative relief is probably our really best avenue, we want to let you know we're trying to pursue that. We're trying to do everything we can so that it's not, so that you're not walking a plank or you're not backed into a corner by rules, even though there are unique circumstances in this case and in this regard. So again, greatly appreciate your time. And we do have a little more time left. Michael, you haven't commented yet. If you have anything to offer right now, or others, or if anyone else who has taken the time to attend this would like to offer a comment, certainly have time. Sloan Shoemaker, I see you for the Wilderness Workshop.
Shall we give up the chairs?
I don't think so. She doesn't have a full presentation here.
No, just try the comments. I'm Sloan Shoemaker of the Wilderness Workshop, and we're a supporter group of the Thompson Divide Coalition, and yesterday Senator Bennett was down at Carbondale and he addressed the Thompson Divide issue and the issues from those leases, and a couple of points he made were underscoring again today that it'd be his desire to see time given before a unitization decision is made, time given to allow these deliberations and the discussions between TDC and the leaseholders to play out, so that we have an opportunity to see if there's a solution, a resolution to these conflicting values before a unitization decision is made. And he said he would have that conversation with Secretary of Interior Salazar to the extent that makes a difference. So that's very helpful. And there was an article in Grand Junction Daily Sentinel this morning where Mr. Tipton's staff person made a comment to the fact that they didn't see the viability of using federal dollars right now in the current budget situation to buy out any of these leases. And I don't think it was ever the intention of the coalition to use federal dollars. If there's to be a buyout, they aren't
I
targeting
didn't see
federal
that
dollars.
in the draft bill I'm looking at. It seemed that what the gist of it was either private money to purchase leases, voluntary exchange, donation, and or maybe authorizing BLM to offer other leases of equal value in exchange for.
Okay.
That was, I didn't notice anything.
No federal money will be used.
Yeah, just to make sure we're clear on that.
Right.
So that's not an impediment, at least in your.
Yeah, no, from what I've seen, that isn't even on the table. So.
To the credit of the representative from SG, he was at a meeting in Carbondale yesterday, and we had a chance to talk afterwards, and I think the door is open to to really engage in more substantive dialogue with at least Eric at Sanford, who represents SG. So I think, Senator Bennett's admonition, and also from your office, is keep talking. I think we can report that the door is open, and those guys have said, yes, we're willing to come down and sit down and start talking again. I think if a buyout, lease buyout is a strategy, one of the strategies to extinguish existing leases or address existing leases, is ever to occur, it would be really great if SG, of course, is going to come to the table with their perception of what the value of those leases are. I think for those of us interested in not seeing drilling happen there, that we have the opportunity to get an independent valuation and assessment of the mineral resource there and the potential. And that would be a very expensive thing to do. And I don't know if the Pickett County Commissioners and maybe Open Space and Trails has money to help something like that if it were to occur. But we would certainly help, if I may speak, or if you may speak.
That's why I'm working legislatively.
Yeah. Thank you for those comments, Sloan. Appreciate that. Was there anyone else back there? We have a fairly awkward meeting room. I can't really see behind the pillar. Peter?
I just have a couple questions and clarifications after Jerry and Steve spoke. The first is about the contraction of a unit, if that unit agreement isn't complied with. My experience is that contraction of a unit will happen, but not automatically. It actually takes administrative action to do it. And that extensions can be granted even if a unit agreement isn't being complied with.
I think those are both true. I can't think of a unit never contracting, though it was supposed to.
Okay, I can give you an example. The Willow Creek unit, which is actually in the Thompson Divide, also.
And was that suspended, or?
An extension was granted several times, maybe 4 or 5 times, and it wasn't actually until we intervened that unit contracted. So it was definitely not automatic. But so that was one question. The other thing I wanted just to raise was, that agency regulations are explicit in saying that an agency cannot issue leases in violation of their own regulations or laws in place at the time that the lease is issued. So for an agency to say that we just follow the regulations and once the lease is issued, the horse is out of the barn, is turning a blind eye to the mandate which says that, if the lease is issued, it's got to be in compliance with regulations. So if you've got a rising chorus of people saying, this is a lease which may not have been issued in compliance with rules and regulations in place at the time of issuance, it's probably worth taking a second look at it. And your regulations would support that second look. Those are the only comments I think I've got here.
Thank you, Peter. Appreciate that. Do I hear the coalition any closing comments? We have about 25 minutes left, but if we've reached the end of... Jack has a comment too.
I was wondering, here we are discussing basically a property right. Rob's, of course, bringing in local economies to the discussion. I'm wondering, unitization, does unitization add value to the leases by simply extending the time? And is that a consideration of the BLM?
It's not of the BLM.
Okay.
Your initial question seems like a reasonable premise, though, that it could add value.
Yeah.
But it is not a consideration of the BLM.
Yeah. Okay. Well, whose consideration would that be?
I would think it would be
of the property
owners.
Yeah. Well, this is a real shame because here we are trying to figure out what move to take in this involved and community effort, and then if value is added, unfortunately, because of timing, you finally get to it, and a lot of F's here. If the unitization occurred, well, then we've just made the challenge even steeper. A question also about, how would I put this? The cooperative effort, it has to be, in order to apply for unitization, did I hear 85% of the leaseholders in an area?
Right, that's our threshold.
And my understanding is that, and Canada is also part of this request in a minor way. They have like two leases.
I think so, yeah.
Okay, so they have SG and in Canada. And how?
In Canada,
In Canada, okay, good.
from Canada, that's right.
Yeah, so, and I will state first that this is hearsay because I haven't sat in the office and talked to anyone from Encana. But it appears to be some element of public understanding that Encana has made statements to the effect that they have no desire to develop those leases. So is there any validity as to, is there real intent here? Because there's got to be an effort of a couple companies. So in fact, if one of them really has no desire, what are they doing? Just combining forces for technical reasons? You can't answer that question specifically, but is there any, in the application process for unitization, is there any validity, documentation, whatever, as to real serious intent by all parties? Is that part of an application? It's a very hard question to ask because I'm not sure how to shape it, so I apologize for the inadequacy of the
I
question.
think I can answer kind of, maybe not directly, but almost parallel. Their unitization has the diligence requirements built into it, so while whenever we get an application for anything, we may not know how serious people are. I mean, whether it's a bike race or an APD or anything, built into those are deadlines and timeframes that they must meet, and unitization does have that in there. So if they fail to meet those,
then it
terminates.
Yeah. Okay, thank you. I appreciate it.
And another part of that question may be addressed by the thing Jerry didn't bring up is unitization requires them to share in the costs of development, even if it's just over in one portion of that unit area. So, like in the case of two companies like Encana and SG, that if SG was to start some of the development on one of their leases, Encana would have to share in that cost. And of course, then they share in royalties too, as far as production goes. But that's another part of that agreement that requires that sharing.
Okay, well then somewhat there's some light shed on my question then just by that, because there is a serious nature of cooperating.
Yeah.
It's going to cost Encana.
Yeah.
Okay, thank you.
George? Well, just my last closing comments. I think what you've heard today, Brian, is there are places that are appropriate for oil and gas exploration, and there are places that are not. And certainly the Thompson Creek area is one of those places that we should protect for future generations for all the uses.
Dorothy?
I was in comment. I started with my sort of old lady representation of what this place was. But I think what we need to do as a county is to look at the fact that, look at each of these communities that once were very separate. We're now one valley. We're the Roaring Fork Valley. And if you look at the changes, Glenwood has a world-class kayaking course. Carbondale has more than one restaurant. It's very gentrified compared to really the entrance to the valley there. Aspen, we've all seen changes. We could go on for days. I think what we need to do is to look at why and what people who live here need and expect and want, and I appreciate this board's support of looking at this valley as a valley and as something that needs to look at the people. And by doing the surveys you do every year that show quality of life and openness and open space and clean air and clean water, they're always top 1, 2, 3, 4. We need to protect those, and I appreciate that. So, I would just end with the fact that those who've worked for Thompson Divide, they're trying to work with representatives and senators in a very crazy environment. And I can't say enough for those people who, from Colorado, have had to endure. When you have to declare a town to be compassionate, we're going to be civil and we're going to like each other. When you have to put that in writing, it's a sad state of affairs. And we have hired people to go to Washington to work for us, and I really have to commend the Colorado delegation. Not a lot of them, but the Colorado delegation has done its job in trying to remain sane in a very crazy environment. And we're asking them to take very difficult positions, and I appreciate it. And the second thing is that staff has been working together, is my understanding, and that Senator Bennett's staff and Representative Tipton is to get back to us for this September meeting. So I think I said that, but I'm not sure. And I have this stuff I'll leave with me when I leave. So thank you very much.
Did you?
Just to let everybody know kind of where we're at for your benefits. After we did meet with the coalition, the congressman did also personally back in May. I've been going through a lot of this. There's just a lot of follow-up that I would like to do, obviously. It's good, obviously, getting your perspective. I want to follow up with Delta, Mesa, Gunnison, Garfield counties, and kind of get some, we've got their resolutions. I kind of want to get some further specifics, background, obviously because we weren't in office at the time those were passed. But I do want to really encourage people to keep in contact with us as things evolve. I think right now, after looking through the draft legislation that was proposed, there are some very intriguing aspects to it. Some of which, again, where we're at currently is we're really encouraging SG. Obviously the coalition has been very explicit about their open door policy, but we would like to get them at the table. And some of the stuff that's in this legislation, hopefully we can see what kind of resolution we can get out of that voluntarily before taking any kind of the next step. So that's kind of the process we're in. We'll keep working with the BLM. Jerry's been great. I've been talking to them quite a bit on the unionization in general and also on this one specifically. And, we'll work with the industry, COGA. We just kind of want to get everybody's perspective and really get a good, thorough background on where everybody's at and why. There's just a lot of moving parts and variables that we'd like to get in order to make a very good, educated decision in the end.
Thank you. Thank you very much for that. Everyone appreciate their time and attention. I'll echo Jack's comments that I really have never seen a citizen group come together as professionally and cautiously and thoughtfully as they have. And there's been sometimes a little confusion, I guess, in the public's mind that Thompson Divide Coalition is not about the hidden gems. They're just two very different sets of interests. There's some territory that overlaps, but this is not about saying no bicycles or horseback or making it into wilderness areas, finding some other type of special designation. We were a little excited about the wildlands policy, as that might be an appropriate home for this, but that stalled out, as we know. And we are still interested as we look at that type of program, the Great Outdoors America, look at BLM lands, that this is most appropriate there. George used the comment, some areas are appropriate for drilling, some are not. I think it goes a little further than that. I think that this is more valuable to future generations undeveloped. And there's a number of reasons, but it's just in today's, I think the Colorado Independent Online, I briefly looked at it before this morning's meeting, but given temperature change and climate change, for whatever purposes it is changing, we're anticipating that there will be 50% less cutthroat trout habitat in 50 years from now. And, I've gone through some pretty lengthy and continued meetings with the Bureau of Reclamation on the endangered fish 10825, Colorado River stretch, and the amount of money that gets expended to try to recover something that you've lost really should not be underestimated. You can look on the one hand of the value of the leases here, but the foregone costs and the saved expenses of trying to rehabilitate landscapes and lands is tremendous for all of us on the public dime. And so cutthroat trout, which has an endangered species and native species, this habitat is critical. There's also strong support, which we've seen from the DOW, about the significance of this wildlife area, that it's not just because it's a great hunting unit today, but when you look at its proximity to the greater intensity of oil and gas development on the I-70 corridor, this is your real chance to see the regenerative herds, the herds that can backfill into that area as the industry finishes its job and moves out. And whether we see oil shale leasing come forward or not, we don't know. But it's very important to have that type of sanctuary and to have the mixing of the herds that does occur also in this sort of common ground. Without that new gene pool introduction and unfragmented masses of land, this could affect the health of the elk in Gunnison, down into the Piceance Basin and all the way up into our area. And so it's really an ecological hotspot in a lot of ways. So we'd like to really see given the inherent value that deserves. So, if anyone else has any final comments, we can go from there. Okay? There being none, we will thank you again very much for your time. Greatly appreciate it.
Thanks for the invitation.
Before we break, I was going to talk about this email, but we have Sloan here, and we have 10 minutes, maybe we could talk about that.
Thank you for attending today. Thank you, Brian, for being here. We appreciate that. Okay. So Sloan, we received your letter last week by email on Thursday about the roadless and gap leases, the window for resolving this now and closing. And so I guess it's a chance for you to explain it a little more thoroughly. I what is the timeline, and what can kick our comments up a little higher than what we've been able to do so far in terms of impact?
Well, our understanding is that the Forest Service is right now, in this week and next week and perhaps the week after that, having conversations with the State Department of Natural Resources, sort of starting to come to some conclusions on the roadless rule, the state roadless rule. And we see that the roadless rule perhaps is one of the best opportunities to get some resolution on this gap lease issue. In fact, it hardly seems like the rule can move forward if they don't address this gap lease issue, because I think there's going to be lots of consternation and perhaps challenge if not. So I sent that to you to alert you to the opportunity now just to weigh in on some of the concerns you've already articulated here this morning. Peter just got back from D.C. He's been having this conversation with folks in the agency, and I'll cue him up to talk more detail about timing and substance.
So we were in D.C. last week talking with people about the Colorado roadless rule and making specific asks, asking for more upper tier acreage, as well as some tweaks to the verbiage in the rule and things like that. But one of the issues left unaddressed, basically, in the most recent, revised draft environmental impact statement on the Colorado rule, is this gap lease issue altogether. So that EIS assumes basically that the 2001 rule is not in effect, which I think is a faulty assumption. I think there's a good argument, actually. We believe that the 2001 rule is in effect, and that their failure to analyze that, at least as an alternative, is a serious vulnerability in this EIS. The gap, of course, is created basically by the Colorado rule. If we were just going to continue to operate under the presumption that the 2001 rule is in effect, then it would be clear that any leases issued without prohibitions on road building would have been issued in conflict with that rule, as long as that rule was clearly in effect. But like I said, that's left completely unaddressed in this EIS. So the ask, I think, is, one, check that assumption that the 2001 rule is not in effect. And we can talk in more detail about arguments underlying that. But two, there are roadless areas that have been roadless areas for 10 years here locally that were leased for oil and gas development without appropriate stipulations, and that needs to be fixed moving forward. If the state is intent on, and Department of Agriculture and the Forest Service are intent on protecting roadless areas, then what they need to do is they need to make sure that those roadless areas are protected going forward, but also were protected under the 2001 law.
Peter, I know there's been such a long history from the 2001 roadless rule going into effect, then being countervened by the Bush presidency's Department of Interior, and then the 2001 rule being upheld by the court. So what was kind of the last ruling that upheld that is why you're saying that it is in effect?
The Ninth Circuit Court of Appeals upheld Judge Laporte, who's a magistrate judge in the District of California's decision to basically invalidate the 2005 rule and reinstate the 2001 rule. And the issue, one of the issues, is that she, in an act of comedy, constrained her.
This is Gail Norton.
No, this is Judge Laporte. Constrained her reinstatement of the 2001 rule to the Ninth Circuit and New Mexico.
Let me explain comedy.
Yeah, comedy is basically when you've got two conflicting opinions, she basically constricted the scope of her ruling to a specific geographic area so that wouldn't conflict with the other opinion, and that other opinion was from a district court in Wyoming, which basically invalidated the 2001 rule. Now that Wyoming court opinion has been appealed to the 10th Circuit. It still hasn't been decided. It's still pending. Until then, we have an opinion from the 9th Circuit, which is an appellate court, therefore it's the highest court, basically reinstating the 2001 rule. So we believe that that's the law of the land. And that LaPorte's constrained injunction on the 2005 rule and then reinstatement of the 2001 rule is no longer constrained because that order was issued under Federal Rules of Civil Procedure, Rule 62, I think, which lasts only until the appeal is resolved. That appeal was resolved when the 9th Circuit validated her decision, and therefore the 9th Circuit decision is the rule of the land. That is where we're coming from.
The chain of events. Okay, thank you. I knew it was convoluted throughout there. And the whole Colorado rule came out of the 2005 rule, which then said that states should set their own roadless plans, and they could either accept a federal plan or develop a state plan. The state roadless rule plan began development under Governor Ritter.
Actually,
under Owens.
Under Owens and then
Ritter.
Ritter.
4 years under Ritter's, and has only now been submitted.
And actually, the petition itself was the reason that it wasn't halted when that 2005 state petition rule was invalidated is because the petition was actually submitted to the Forest Service under the APA. And any state could petition the Forest Service for a state-specific rulemaking under the APA.
APA is
the Administrative Procedures Act. So that's why it continued to progress even after that 2005 rule was invalidated. Yeah. So, the long and short of the gap lease issue is that there are 70,000 acres of leases in roadless areas that could potentially be eroded. So it's a big deal. It's a big deal in the state of Colorado. It's a real big deal here. That's one of the things that another problem with the EIS was that in its air quality analysis, it basically said that there wasn't going to be a significant impact from potential development of these oil and gas leases. One of the reasons that it said is because they're so kind of disparate in timing and geography. Development of those leases is going to be disparate in timing and geography. It failed to take into account that the large majority of those leases, right here, basically from the Thompson Divide area stretching a little bit into the Clear Fork, but mostly in the Thompson Divide area. Very concentrated, and those leases were issued in a pretty discrete time frame, so development is going to happen in pretty rapid succession. Another inadequacy, but really, the gist of that, the point of that is to say that it's communities like Carbondale and the Crystal River Valley that are likely to see substantial impacts from development of those gap leases.
John, do you have any further questions on that, Ely, and to be able to prepare us some comments and a letter weighing in on that, if that's the board's direction that we would like to, I suppose it is to see the Colorado roadless rule respect roadless areas in our Roaring Fork Valley that were roadless and declared so via the 2001 rule, and that should be upheld.
Yeah, and I would say too that there's a pretty good argument, I think, that the Colorado roadless rule itself may not be an appropriate place to deal with this issue.
Right.
Because a rulemaking obviously should be not retroactive, but kind of proscriptive. So moving forward, you get into problems when you try to constrain existing rights. obviously, we contest the fact that these are existing rights, valid existing rights. But the point is, the agency has authority to do something about these leases, whether they do it in the rule or whether they do it in some other discrete agency action, whether they cancel them or whether they just, under their own initiative, appropriately stipulate these leases. And actually, the argument is that they have to do that in order to bring these leases into compliance with their own regulations. What we're asking the agency to do is to address the problem, whether they use the roadless rule to do it or whether they do it through outside means really doesn't matter so much to us, just so long as we get resolution. And it's an important enough issue here locally that we're really pushing pretty hard on that. I would say that given what I heard a minute ago about concerns about NEPA and the original issuance of these leases, it may be worth sending a letter to the state director of the BLM, Helen Hankins, and also to the acting regional director or regional forester of Region 2, basically bringing this issue to their attention and saying that there are a bunch of gap leases that need to be reanalyzed. And we have concerns that the NEPA that was originally undertaken prior to issuance of these leases was inadequate. That's an issue that we're going to be raising with those two officials in coming weeks here. So I might CC them on any letter that you send to the Colorado Roadless team.
And please CC us on any letters you send that we can review your work and take it into account. Other board questions real quick, because otherwise we're supposed to break out for lunch. Does this give you enough direction, John and John?
For right now, my plan is to talk to the board next week.
Okay. Very good.
And we're happy to provide further briefings and information as needed.
Yeah, I mean, what I understand, again, I sent some emails to Bob Randall and also to the Deputy Director of the U.S. Forest Service, and Bob Randall's message back to me via voicemail was that the public comment period ended in July, but he's certainly happy to continue discussion or hearing our concerns.
Very good. Okay, thank you. All right, grassroots will reconvene back here at 1 o'clock. Thank you, everyone.
Sorry.
Thank you, everyone, for being here today. We're going to get the meeting going. It is Tuesday, August 16th, and it's about 1 o'clock in the afternoon. And we are now going to have our annual meeting with the Colorado Department of Transportation Regional Director, David Eller, and Doug Aden, and staff. So welcome, and thank you for being here.
Thank you.
We'll just turn it over to you. Just identify yourselves for the cameras and public record, and we'll go from there.
I'm Dave Eller. I'm the CDOT Region 3 Director. I was up here last year and trying to get a little earlier this year, so if there's some things we need to fix or work on before winter, we certainly can try to do that. And, appreciate you guys having us in here. And we'll try to go through our book, as we usually do, and try to hit the high points, and then we'll hopefully have some time that you guys can ask us any questions or let us know how we're doing and some of the needs you see. But I'll let Doug start us off with some of the financial issues where we're at with our budgets.
I'm Doug Aden. I live in Grand Junction. I represent Pitkin County and 10 other western Colorado counties on the Transportation Commission. I'll talk about the budget, which is under the tab in the booklet called Funding. If you go to, you look at pages 8, 9, 10, and 11, and I'll talk a little bit about where our revenue is coming from these days and how we have it budgeted to spend. The CDOT budget for the fiscal year that just began July 1st is a little over $1.1 billion. Well, that seems like a lot of money. I've been on the commission almost 14 years, and that's about what the budget was 14 years ago, and we've had some ups and downs with bond proceeds and general fund revenues from time to time, but if you think about just the loss of purchasing power to inflation, the increased demand on the system in terms of more vehicles, more population, more vehicle miles traveled, we're not making a lot of progress at this level. Then that little pie chart up in the upper left-hand corner of page 8 kind of shows the breakout of the funds. $460 million of it comes from the state HUTF, the state's share of the motor fuel tax. About 89 million of it now comes from the so-called FASTER legislation, which was passed in the 2009 session of the legislature, which increased vehicle registration fees. There's some miscellaneous sources of income, and then the other large chunk that accounts for a little over a third of our money is the federal money, and that's the federal share of the motor fuel tax that comes back to us in Colorado. I guess the good news is that the state side of the budget is fairly stable for right now. The motor fuel tax, I think there's growing evidence, is not going to sustain us into the future. Even though there is more, as I said earlier, more vehicle miles traveled, the fleet of vehicles that we all drive out there is much more fuel efficient and getting more fuel efficient. And the gas tax has actually started to decline a little year over year at both the state and federal level. And you hear more and more discussion about the automakers coming out with some very, very ultra-high fuel economy vehicles, and of course vehicles that are now probably going to be operating on something other than fossil fuels. And so, at least at its current level, there's no future in the motor fuel tax. And we haven't increased the motor fuel tax in Colorado since 1992, and at the federal level since 1993. But certainly the FASTER revenues have helped, and they're still ramping up. There will be one more year of an incremental increase to those, and so that has really helped us address the need to replace substandard bridges and to address some of the critical safety needs around the state. The biggest cloud hanging over this whole thing right now is on the federal side, for two reasons. One, the last federal authorization expired almost 2 years ago, September of 2009, and like many things these days, it seems like Congress is just struggling to agree on anything. We're almost 5 years into a series of continuing resolutions on the aviation side with the Federal Aviation Administration. We're now almost 2 years into that same sort of cycle on the surface transportation side, and I think there's every reason to believe that because of the politics, nothing will happen for sure before the presidential election. So there's a lot of uncertainty hanging over federal funding, and the federal funding is now getting caught up in this whole budget discussion that's going on in Washington. The other thing we've probably seen in the newspapers or in the media recently is that federal fuel tax is 18.4 cents a gallon. 14.3 cents of that per gallon expires September 30th of this year, and will expire unless Congress takes specific action to extend it. And again, given all the politics of the budget, there are some in Congress who are saying they should just let it expire and that the federal government ought to get out of the transportation business and let the states do it. So I don't know where that's all going to go, but there's an awful lot of uncertainty hanging over 1/3 of our budget right now. So that's just, I guess, the political reality of what we're dealing with.
Todd, I had heard fairly specifically that if there's two different proposals, one to do some sort of extension that's kind of the Senate proposal and with comparable revenues as today, and the other is to basically use the balance in the federal trust over the course of the whole next 6 years and just spend it down without any sort of reauthorization and continued revenues. And that if that House plan passes, Colorado's share would not even be enough to pay the annual trans bond payment.
Yeah, there's two bills, one on the House side, which would significantly reduce funding to all the states. And I think what the House bill says is all we're going to do is spend whatever comes into the trust fund. Congress has been spending more than the trust fund has collected for a number of years, and at one time there was a surplus in that trust fund. They spent that surplus down, and then in the last 2 or 3 years, but really for the first time in history, they started to backfill it with general fund revenue, which all they're doing there is increasing the deficit, which politically today is not very popular.
Yes.
The Senate side, bill on the Senate side would sustain revenue or funding at pretty much the existing levels for 2 years, which would be better for Colorado, but I just don't think there's a lot of political support for that. I don't think, like a lot of things, I just don't think they're going to be able to reach a compromise. And at what level, if they continue to do continuing resolutions, the question is going to be at what level of funding are they going to authorize. And if all they authorize is the level of funding that's available from what's coming into the trust fund, then we could see a significant decrease in federal funding in Colorado starting very soon.
Do you know roughly what those trans bonds payments are? Don't they go through?
It's $168 million a year. And if you look at pages 10 and 11, it shows how we spend our money by various investment categories. And to Rachel's comment, if you look at the last section on the bottom of page 11, or excuse me, right above that, where it talks about the strategic 28 projects, the $167 million, almost $168 million, that's the debt that we owe for the money that was borrowed for the seventh pot projects. Of course, the most notable one here being the 82 corridor was part of that program. So that's kind of like our mortgage payment. That we have to pay that right off the top, and we're obligated for that debt service out through fiscal year 2017. So we've got several more years.
Just a quick question. If the feds decide to take away some or all the funding from this to the states, would that also include funding for the interstates? Would they expect each state to maintain the federal interstate program?
Yeah, I mean, really, and that expectation has been there for a long time. I mean, the interstate system was built with largely federal money and then turned over to the states, and the states are have been for a long time responsible for the long-term care and preservation of the interstate system. So, but certainly we still get a significant portion of our revenue from the federal side, and so if that went away.
So then just a quick follow-up, so the discussions on a new tunnel, right now you're looking at using mainly federal monies for that, projected?
Well, this budget, I guess one of the things I would say about this budget, all this budget really does is provide for basic maintenance of the existing system, and not even a very good job of that. This budget, if we continue at this level of funding, or even less, but even at this level, there is no money in this budget for the foreseeable future for any kind of capacity or mobility improvements to the state highway system, of any kind. I mean, talk about tunnels.
It sounds like a similar conversation we're having on the county level.
Yeah. So, just to give you an example, if you look at system quality on the middle of the page 10, that first line, we $147,220,000 for surface treatment. That's the repaving of the roads. We know from our management systems and information at CDOT, we should be spending at least 3 times that much money annually. And so that's the kind of thing the public's going to start to see. The public's going to start to see the condition of the roads deteriorate because we know we're not spending the kind of money we need to spend in order to maintain them. And as I said, there is really no money in here at all for any kind of significant capacity. I mean, we talk about the I-70 Mountain Corridor, we talk about any of the major congested areas in the metro area. I mean, you name it. Those projects right now are just something we hope for sometime in the future, but the reality is there's not much money there. You can see on the bottom of page 11 there how we spend the FASTER funds. About half of that money is dedicated to the bridge program, where we're working on replacing those 120-plus structurally obsolete bridges, and we're making good progress on that. Roughly the other half of the money goes to safety programs, and we've worked with the various TPRs around the state, in your case the Intermountain TPR, to develop a list of priority projects that we'll work on as those funds become available. And then there's $10 million and $15 million dedicated to 2 different transit programs. One for, it's distributed locally through the TPRs, and one that we choose projects on a statewide competitive basis. So we tried with our maintenance folks are here. We've tried, the commission, to try to keep the maintenance budget from taking too many cuts. I always feel like we send those guys out in the field every day with one arm behind their back, because don't really give them the resources they need to do their job, and I think they do a great job given the limitations they have, but the commission has tried very hard not to cut that maintenance budget too hard. The areas of the budget, 2 areas of the budget that have really taken the big cuts are, some of you may remember the old regional priority program, and again, that's where we used to work with the TPRs and MPOs around the state to help fund projects that had been identified as by the locals as priorities. That portion of the budget is gone completely. There's no money for that. And then we've had to even cut the resurfacing budget, as I mentioned earlier. So that's kind of where we're at. I'd be glad to respond to any questions. Dave can address anything more he wants to say.
Speaking of maintenance, on the it's not new any longer, but it seems new, Rim Creek Bridge, there was an overlay of, I think, epoxy and aggregate material put on the bridge, and that's wearing out in the tracks that the wheels form. Is that important to maintain that coverage, or does it protect the concrete?
Toby, do you know much, or Dwayne, I know we put an epoxy coating on that concrete deck, with a bare bed deck, right? We put that epoxy coating material.
Yes, we do.
I don't know, I didn't notice it was wearing out, but
And I haven't noticed that either, and it will wear, and eventually it will have an effect on the rest of the bridge.
Well, so I guess that's my point then.
we need to keep it sealed. The concept of that epoxy coated, it's kind of a new product, basically. It's, a lot of times you put a membrane on a bridge and you put asphalt over it. That product's supposed to seal your deck, protect your deck, the same as a membrane would do. At less expensive, lower maintenance cost than membranes and asphalt on top. A lot of times with membranes, asphalt on top, it shoves around, moves on you, so we've had a lot of problems with that in the past. So kind of a new concept of sealing a concrete bridge. I think our region materials engineer has been kind of the one leading effort on trying those, and our bridge group out of Denver, and I'll certainly pass that along. We need to look at it, see how it works.
Yeah, I don't know what, are you guys going to go down Valley? So you'll have the opportunity to check it out, and you'll see where the project is going. So I'm just...
No, it's a good comment, because it's kind of a new product for us, and
Yeah.
it's really a little less expensive than the membrane asphalt if it can make, say, a 10-year life cycle. But
Yeah, so it hasn't quite made that. I mean, there's so much wear in particular parts of the highway that they take much more wear than other parts. And the other question, this is all maintenance, is on, I guess it's in the canyon. You have the same problem where you have, it's not rutting, but you have depressions in the tire tracks. And so then in that canyon, you have joints, steel joints, at certain areas. And at those steel joints, because of the rutting, you're really getting an impact. That doesn't wear down, or at least as fast. And so you get this impact when you're in those ruts. And that's, I think that needs to be looked at too.
And I think, Michael, I agree with you. And the other thing I would say is those are two good examples of the kinds of things, if we don't figure out a way to change this budget, that it's going to be harder and harder for CDOT to do on a statewide basis, because every county we go to, all 64 counties in the state, can probably give us examples of those kinds of things that need to be done in their county, and eventually we're going to just stretch the rubber band so far.
Yeah, I don't mean to put inordinate pressure on you, but these are things that you might not notice, and when you talked about maintenance as being sort of the last bulwark against complete deterioration, and so I just bring it up, and they're not huge items, they're just items within...
Yeah, they're not big capital type items.
But they probably could be, with finesse, addressed. So, and then the other question is, there are various communities, Aspen, at the ABC, Basalt, Algebel, all looking at planning processes for crossing the highway. And CDOT is involved in those, at least in the planning process. So how does that look for the planning process? Can CDOT be actively involved in those processes?
I'm not sure I understood your question.
Well,
as far as the planning for pedestrian crossing?
Yes, pedestrian crossing. At ABC, at Basalt, and particularly at Algebel, there's been lately a concern about a community center going there, and the increased traffic, what that would do, and RAFTA, and so forth and so on. So it's just about, can we keep coordinating that process, or are you out of funds even?
Well, there's some things going on. Will Wagner, our resident engineer out of Glenwood, I know that there's some enhancement money, right, to look at a pedestrian overpass somewhere along there?
At the ABC, there was some faster funding that was allocated for the construction phase.
I think it's RPP.
Is it RPP?
Yeah. It's RPP.
And we're working very closely with Brian Pettit and GR on that effort. They've recently selected a consultant. There'll be a full public process there. Is it going to be an overpass, an underpass, those type of things. In Algebel, were you referring to the Crown Mountain?
Yeah, I mean, the whole intersection there is problematical, at least for Eagle County. And I think probably for every resident has to go through that intersection, so.
Eagle County's kind of taken the lead on that. There's some unique issues there with a RAFTA BRT facility that they're planning on, and there's an existing underpass, and how that ties in with a new connection to the Crown Mountain multi-use facility there. We're very involved with that, myself and our access people at Grand Junction. In Basalt, again, there's some issues there with RAFTA BRT and their facility. And at one time, Basalt was looking at maybe doing an overpass bridge there. But we're very dialed in with all the local governments in those planning processes.
And you have the funds to do it, to at least be involved in the planning process? I'm not talking about eventual, building, but...
It's really just part of my job. I mean, that's
Okay.
we have a residency in Rolling Springs with a staff of engineers, and either myself or some of my engineers will be involved in those processes if we need to be.
Yeah, and because I think, the highway actually is working fairly well to go up and down it. But the problematical thing about Highway 82 now is crossing it. And particularly if you're going to have a successful transit system like RAFTA, if the crossings are sketchy, or you can't, if you're a single mom with your 4-year-old, and you can't really get across those crossings, you end up not using the transit system. So it's a community-wide and valley-wide problem that we're all trying to address in some form or another.
And Commissioner, I'd add that at our Intermountain TPR, some of your commissioners know, been there, there's enhancement dollars, federal enhancement money that gets prioritized, and we try to spread it around to the counties evenly, and the counties will bring in projects, and often pedestrian crossings, safer bike crossings, they're eligible for enhancement dollars. Now, enhancement money is a federal funded program. It's not a big pot of money, but it's a little bit of money, sometimes enough to at least get design done, sometimes to get construction done. Obviously, get into bigger structures, it's a little harder to put the peanuts together to get a big enough amount of money. But some of these projects come up through the enhancement program. Now, Commissioner Aiden talked about the federal bill. One of the things with, just as a little piece of information, the MICA bill that is a new 6-year bill. The interesting thing that doesn't get a lot of talk about, everybody talks about the money, but that bill condenses a lot of the federal programs. There's probably too many out there. Depends on who you ask. There's a bunch that directs money to certain things. It has to go here, it has to go there, just like enhancement. It has to be used on this type of project. Well, the MICA bill significantly condenses that. So if that kind of a bill comes about, you may see some of these programs dried up first. Some of these trails and enhancements and things like that. Because it actually kind of gets away from some of that specific direction of federal funding. So, that's what we do now. That's one way. Another way, we have this faster safety money. And if we have some real safety issues at intersections, pedestrian bikes, I'll let Zane, our craft engineer, talk about a piece in this book. They went through and asked each county and each municipality to give us the highest priority for your intersections. What's the most unsafe intersection? And some of those things that are coming up are related to pedestrians, bicycles crossing, things like that at intersections. So you have this faster safety money that Commissioner was talking about, that the TPRs have taken 5% off the top, so we want to focus on hotspot intersections in our region. So another method, you might be able to get a little bit of money towards some of that. So you ask, from a bigger picture, is there money out there? There's a little bit, and we address them a few at a time. But there is some of that effort still going on. So some of these you talked about, there is planning and even budgeting of money to some of them.
Yeah, and I'm glad to hear that. That's wonderful. I mean, I think, for 82, it's been a successful corridor for mass transportation. And with the BRT, I think it's going to be even more fruitful. But if we can't cross the highway safely to get to bus stops, it puts that, then people return to their cars, and then you have congestion and all the problems associated with too many automobiles. So it's, I don't know.
Well, that's good. And honestly, some of the faster transit the Commissioner talked about too, that bill, the faster bill, allowed for using faster transit money to connect to transit facilities. So if we're talking, a pedestrian pathway transit facility, some of this faster money can be directed towards those types of improvements, which is good for what you're talking about. It's strategic, it makes a lot of sense, and we've done some of that. There's not a lot there for our region, but some of that's being discussed, how we better connect our transit facilities. And unfortunately, the Faster Safety is one of those programs that every year legislation, depending on who you want to talk to, there's a lot of folks like to get rid of it. So it's always one of those that from year to year, we're not sure what's going to happen with our Faster program. But let me, if you would, I can talk with it a little bit.
Let me let you get back on your agenda. We'll hold our questions.
And I just want to make one final comment before I pass it on to Dave. Pages 12 and 13, which talks about the revenue projections in the 2035 plan. I guess the only thing I would say is I wouldn't pay much attention to that. I think we're required to do a long-range plan by federal law. We're required to make these revenue projections. There is so much uncertainty around our funding that we can't hardly project, 3 years into the future, let alone 30 years. So don't take any of this money on 12 and 13 to the bank because it may or may not be there. That's my caution there.
Okay, with that, I'm just going to back up. I'm going to bounce through this real quick in the interest of time. Some of the first pages on here just talk about our region. You've probably seen this before, so I'm not going to spend a lot of time on it. We are the largest geographical region. We have 2 maintenance sections. One basically splits our north side of our region. That's Section 6, operates out of Craig. Section 2 is the south, the interstate area. And that's out of Grand Junction, managed by Superintendent Toby Brown, who's here. Wayne Gaiman's the supervisor out of Glenwood Springs for this area. Okay, and I'll let those guys speak to their piece here in a minute. Engineering sections were broken into basically 2 program areas. We have what we call our Program East and our Program West. I'm on page 4 here. So we got, really the Program East is more of a central I-70 corridor. And the west is either side of that. But Joe Watson, who's not here today, poor guy's on vacation, we let him have a day off, I don't know why. But he represents Garfield, Eagle, Pitkin, and Lake. And Roland Wagner works for Joe as a resident out of Glenwood. Our traffic section, Zane Zamanic's here today. He handles all of our traffic, access issues, striping, signing, represents the whole region. He's here today. Answer questions. Doug's already talked a lot about the funding. One thing that, just real quick, he says, don't count on our planning. Just as example, and Doug says this every time we go to the TPRs and we sit down and we talk about our 20-year plans. The program that you see on page 11 called Region Priority Program, RPP money, that's the money that we usually go out to the TPRs and they give us their priorities. Okay, they say, we want to see a widening in Carbondale, okay, as an example. And they compete with the other counties and the other locals, and we prioritize the money. As you can see in this year's budget, there's $10 million statewide. In our planning, we had planned $8 million for our region. Okay, so you can see we're down to less than probably, I think we're right at $1 million for our region. So Doug always says, we go to these planning meetings, well, don't get too excited about this plan because the money may or may not be there. We have to plan. We have to prioritize what they are so we can start designing on them and start working on them. So if we do get money, we're ready to go. But often we'll plan for an optimistic, and this is just an example of one of the first programs that often gets cut is new capacity, new improvements, shoulder improvements for a lot of our highways, things like that that often gets cut. And this is just an example of what happened this year. We went from about $8 million in our region down to $1 million. So at that point we have to readjust. We say, all right, we go to each TPR and you're not going to get everything you asked for. We got $300,000 for your TPR instead of $2 million, so we just have to backfill and adjust. And we've been doing that quite a bit for the last few years, just with the volatility and especially federal funding. With that, we move right on into, we'll go to our FASTER program, which I've talked a little bit about, is probably our most stable right now at CDOT, even though every year it seems it's on the bubble. We have our bridge program. Interestingly enough, Doug talked about our bill has a piece that says this is going to be for our worst bridges in the state. And I think I read an article the other day and there was concern about, well, how much does rural Colorado get and is this a reasonable fee for bridges? Well, you can see the bridges on page 20 that are on the first list of 130. And our region, we don't have a whole lot of them, but we have some pretty significant ones. One such bridge is Grand Avenue in Glenwood Springs, and that's probably all close to you guys. You can see the estimated tag on that's about $45 million. Before this program, our region was getting about less than $5 million a year for our whole region. So to replace a structure like Grand Avenue Bridge, you could see that would be like 8-9 years of funding when I talk about bridge funding from the federal government. Okay, we'd receive in our region about $5 million a year. So this is one of the bridges that's competing as one of the worst that we're going to do with this Faster Bridge program, and it's an estimated $45 million. So without Faster Bridge, would this bridge even be realistic? I'm not sure. You know, that's how important that is to us right now, that Faster Bridge program. Another one, the TPR is up on Highway 24, the UPRR bridge, that's under construction. Not your county, but certainly is Intermountain TPR. And then there's two bridges here on I-70, Eagle Vale bridges, that we're working on design right now. And actually I skipped one, the second one up there is US 6 bridge at Eagle. So really this TPR has 4 of our 7 bridges that we're working on under this program. Faster safety, there's a list on page 21 of the projects under construction. There's several projects that we have going. One of the big projects that received quite a bit of faster safety was the I-70 Vail Pass. And what we did there is we had a surface treatment project, but we had all those barrier issues. If you look at the Type 4 concrete barrier, it's in pretty poor shape. A lot of places it's fallen apart, and we took some of our faster safety money and put into that project. We've done some deer fencing on Highway 82. Shell Bluffs Rockfall was faster money. We're doing a critical culvert up on 24, another critical culvert on US 6. So you can see we've spread that money for a lot of repairs of our system, but we feel they're safety risks. We lose some of these larger culverts, we get a sinkhole, we close the road. We know they're in poor shape, so we've directed some of the safety money towards those things. Rockfall, Shell Bluffs, our rockfall program statewide is significantly underfunded, so we've directed some of our region faster safety to high priority rockfall areas. And I don't know if you have any questions on those. Some of them are completed, some of them are still ongoing. But, that's a list of the faster that's working right now in construction. Page 22 shows some of the things we're working on in design. We have some more deer fencing on 82. I-70, some deer fencing. And 133 received a little bit of faster money coming next 2013, Roland, is that right?
Fiscal year 13.
And we're going to try to do some intersection work down there around Carbondale, some safety improvements. This cross culvert on Highway 24 is another big culvert that's undersized, had a lot of flooding issues, and we're designing that right now, trying to get it on the shelf. And this Highway 13 is a big corridor that Roland's working on out of Rifle up to the county line that he's kicking off. And again, if there's any questions on any of these projects, Roland can answer them. But the next part goes on down to show kind of where we're at with faster safety in page 25. You can see that each TPR, we're trying to get even money distributed. It's not necessarily we split it evenly every year. You know, sometimes one TPR in one year will get more money than the other. And we've been trying to plan this on a 4-year cycle. So you can see that Intermountain TPR over fiscal year 10 to 13 received about $12.7 million of this faster safety money. And it's pretty comparable. The TPRs have got a fair distribution. Now, the reason I bring that up is we're entering into our planning for 14, 15, 16, and 17. So we'll be going to TPRs with some of our ideas for faster projects, hearing what the TPRs think are priorities for faster safety, taking those back, looking at, they have to have a safety component, a lot of accidents, no shoulders, whatever has to somehow relate to safety. That's part of the bill. So we'll evaluate how those projects fit, and we'll try to figure out the next 4 years of planning. And that effort's going to be starting out here this fall, spring. We'd like to have that done by next July, so we can kind of get our next 4 years of planning done. If you look on page 26, you can see that it comes out about $15 million plus or minus per year projection for each TPR. So that's how much money over 4 years we'll be planning on finding faster projects. And some of these things, Commissioner, you brought up, pedestrian overpasses, things like that, they all qualify if they're a true safety need, if that's the TPR's direction for prioritization. So we're going to try to work with them and identify projects for the next 4 years. Actually, I should say that starting in 14. The faster transit, a lot of information there on 27. I'm not going to go into a lot of it. Hopefully you guys have heard some of the spill. This county's received a lot of faster transit money up in here, and I think it's got a list of projects on page 28 that shows some of the distribution. Raft has received some good things. They've been at the Intermountain TPR and got some battery replacements. I think there's a bus purchase in there, some ITS stuff, so you can see how they've competed for some of the faster transit monies. And with that, I know that was fast, so like I say, if there's anything there, feel free. I'm going to let Zane come up and talk about the intersection stuff.
Jack?
Yeah, before we go, could you take a quick moment and explain the mechanics of the deer fences? I'm not sure how it all works. I've had several questions and I can't explain it. So how,
The ramps?
what they look like, yeah, the ramps. Would you attempt to, somebody give us a quick explanation?
Basically, the deer ramps, the fence is 8 foot tall. The height of the ramps is 6 foot tall. It used to be 8 foot, but we've worked with the DOW on projects recently. So it's basically, if an animal gets within the right-of-way and needs to escape, that's its escape point. And so, they've got about a 6 foot drop there, which is safe for the smaller animals. That was one concern with the higher 8 foot ones was like a small elk or a small deer jumps that, breaks a leg. It's not good. 6 foot seems to be working fine.
So they're intended as an exit because I guess what an animal has to either jump the fence somewhere or come down valley or up valley of it. That's what happens?
Yeah.
Okay, so it was not really an attempt to control access but egress.
That's correct. And we work very closely with the Department of Wildlife on those locations. They're not just arbitrarily placed every half mile. We consult with the DOW. They give us the migration routes. They tell us where they want them and things like that. So they're most effective.
When people ask what the rail up the middle is for, I ask that question.
Is that a handrail?
It is. It's for older fellows like you who might need help getting up that steep grade.
Great.
But actually, the DOW, there's some scientific theory behind it. It's actually to try to force the animals to turn. What the DOW said is if they get caught in there and they run along the fence, there's a chance that they'll simply run across the ramp and keep running along the fence line. The idea of that railing there is to force them to turn and go up the ramp and go over it. So
good. Now I'm educated. Thanks.
Thank you. Mike?
On the rockfall netting, particularly in shale blocks, is that just to intercept rocks that might spill onto the highway? It doesn't actually prevent rock fall, does it?
Yeah, at shale bluffs, it's kind of a unique situation because if you've ever been out there, you can literally hear the shale weathering while you're standing there. It pops. The idea is we've got 2 layers of netting. One, the first mesh is a tighter mesh. It's sucked up against the hill as much as we can to contain as much of that. And the secondary netting is to catch anything that pops off. So we know over time that shale is going to continue to weather and ravel back, so that the netting is just a system to contain that so it doesn't get onto the road.
Drops in the ditch, basically, rather than...
Between the Jersey barriers and the shale bluff itself.
That's right.
And then that's cleaned periodically?
Yes.
We really appreciate that work being done now. It's always a danger area. I know it's one of the top 3 rockfall areas in the state, so Georgetown, and I'm not sure the other, but it's somewhere near us.
And some of those are, I think that one was one that was out fast and was scheduled 4 or 5 years out, and we were kind of waiting. And when the faster one came along, we said, well, there's some priority things that we should do on that.
We appreciate it, taking our safety and concern. Please continue.
Okay, I'm Zane Zanamacek. I'm the traffic engineer for this region, so I'm in charge of signs, stripes, traffic signals, permitting, those types of things. So one of the things that I wanted to update everyone on was a project that that we sort of touted at last year's county meeting, and that is this intersection priority study that we embarked on over the last year. And if you recall, this project was something where we actually asked every city and every county to provide locations to us that they felt were a high priority for safety. So we've gone through that exercise, and we've put together a complete study, and we published that study. And so if you look on page 30 and 31, you can see kind of a snapshot of how things came out for the Intermountain TPR. And if you recall, the purpose of doing this study was really just to help us in the planning cycle that we're coming up on. As Dave mentioned, we'll be planning for 2014, 15, 16, and 17 pretty soon, and so we're hoping that these rankings right here can help provide some guidance on what we think would get us a lot of bang for the buck safety-wise when we're just looking at intersections. So if you look at the list, unfortunately, Pickens County submissions are a little bit farther down the list, but there are a lot of good projects on the 82 corridor that scored pretty well. I noticed there's even one on here. Maybe there's even two that recommend grade separated pedestrian facilities, so that kind of ties in to some of the other discussions. So hopefully this document will be valuable to everyone. It certainly will be valuable to us in traffic as we look at how we're going to spend our safety money that we have. So
that full document, Dave, we distributed a note to each county, each city participate. Is that how we did that?
That's correct. I believe Brian should have received a copy. You got it right there? Yep. So, and then that's on the website as well. So
It's right here at the bottom of,
did that make it on the sheet?
yeah, it's at the bottom of page 29.
And it goes through and identifies how they prioritize this, all the factors that are
If you
in
want to look at the whole methodology behind our scheme, it's in that report. So that's that. Otherwise, from the traffic program, the other big project that we have going on in this area is we're soon going to be doing a project in downtown Aspen here, a signal interconnect project that's going to be linking all four signals in downtown Aspen here with fiber optics, and also putting in a lot of underground infrastructure so that in the future, over the next 2, 3, 4, 5 years, we'll have that underground infrastructure in place to start rebuilding and maintaining those signals that are down there. They're getting to be some of the older lights that we have in this region, so this is kind of a first step in that. That'll also give us communication ability so that we can access and troubleshoot those signals remotely. So the scope of that project is downtown here. It also goes, I believe, all the way out to the ABC intersection, so it'll be a good project to get all those signals on sort of one system. So that'll be starting up in mid-September. You'll see some workers out there. It's about a $700,000 project. Otherwise, in the traffic section of the book here, we have sort of the standard FAQs that we always put in here, just to provide a resource for some of the common questions that we get asked. And then the last page on 34, we've got some names and some contact numbers on various people on the staff who work with various issues. So,
Thank you.
do you have any questions related to that stuff? I'll be happy.
The other one I was really going to mention or ask about is outside of Pickens County, but it's a road connecting us, and that's Independence Pass, Highway 82. And, well, the work that's been done with Independence Pass Foundation, your organization, and others on our side of the hill seems to have really stabilized a lot of that erosion that was really undercutting it. But when you start descending to the Twin Lakes side of things, there is some erosion that, really looks like you could see, a large chunk of the road slide down the hill. And there's a couple places where the white line actually disappears and on the shoulder side. Not a good sign. And I know it's been repainted for the bike race a little further in. I think that it's just something that to really keep a mind on, because I don't know what it would take to restabilize underneath that road, but if it gets much worse, it would really affect a lot of summer tourism and business for the Twin Lakes side, the Lake County side, which, is a kind of impoverished county and really depends on that summer tourism quite a bit. And it would affect our traveling public as well. So I wanted to try to throw that out, and also to thank you for the work that's been done, kind of getting the road in as best shape as possible for the bike race coming up. This should be exciting. George?
Yeah, I was really impressed. I was up the pass over the weekend, and I was really impressed with the work you did on this side, on the lower part. You did a pretty good section, and you did an overlay. And going all the way up the pass, it looks in great shape for the bike race. So I don't know if that was specifically for the bike race or if that was in your normal cycle of maintenance. But
We can let him come up and tell you all about it. That's our maintenance guy, isn't it? Now, Toby, if you want to, come on, you can go ahead and go next. If you want to talk about your stuff, and I think you and Wayne, I know they've been working at it, trying to get things ready.
Thanks. Come on up, Dwayne. My name's Toby Brown. I'm the maintenance superintendent of Section 2. Appreciate the comments on the past. I'm really proud of some of the work they've done up there. There's, aside from, I think 25, 30 of our people that have been up there for the last 2.5 weeks, we have 2 con crews, one from Buena Vista and one from Rifle. They're working too. Dwayne, if you'd like to expound on that a little bit.
Yeah, we've just been doing, this basic maintenance stuff, and we're kind of combining it all into a short period of time to just look as good as we possibly can before winter. And there's just a lot of work up there that needs to be done, and it's not one of those highways that generally sees a lot of money because it's a seasonal road. And so we just kind of combine all our maintenance efforts for a short time.
And the chip seal wasn't an overlay, but the chip seal you were talking about on this side was normal programmed work. It had nothing to do with the bike race. We don't foresee getting any maintenance money to large engineering projects on 82. And Dwayne's got a project or a cycle where he starts at the top and just slowly works his way down doing chip seals, and then when he's done, he goes back up to the top and starts over again. It's an ongoing process just to try and keep the road put together. On the other side, on the Lake County side, there's not an IPP on the other side. There's not an Independence Pass Foundation on the other side, so it's a little more difficult to find funding and put projects together. We have been trying for, I think about 5 years now to do some stabilization on some of those eroded portions of the road. And the estimates keep coming in way higher than the funding we have in maintenance. So they just keep getting pushed back. We're aware of it, but at the moment we're kind of stuck.
Yeah, George?
So I know recently that the Independence Pass Highway 82 has been designated nationally as a scenic byway. Does that open up any additional funding to help with those maintenance issues?
Not that I know.
There's some money that's specific to national scenic byways, but I don't know.
It's a competitive grant process. I mean, it allows us to then apply for that, but then, we compete against others, so I guess that...
I don't know if we're going to put anything for it. It might be something for us to check into, see if we could get into that competitive grant. It's pretty minimal money, but every year it's a federal program. You can put in a grant application. We have not, that I know, put anything in that area. So we have put in, there's several of those. The Forest Service highways is an example. 133 out of Carbondale over the top is a Forest Service highway. We've been putting in for grant money for that for, 10 years. We're the point where we don't compete well with some of the other Forest Service highways because the Forest Service is also putting in for grants for their own maintenance of activities, and so we're kind of at the point where I'm not sure we're going to see that. The money's pretty tight in those grants. It used to be a little more, those federal programs had more money in it, but certainly something we'll look into, Commissioner, and see if there is something out there under a grant program that we might be able to look at.
Yeah, I don't know if we can be of assistance, or we can write a letter of support from this side. I'm sure Lake County Commissioners would be happy to write a letter of support on that side. That can help in that process.
Yeah, let us look into that one and see if there's something out there, because I don't think we've pursued it, to be honest.
Page 42 in the book is beginning of the maintenance portion of it. I'd like to
Sure, these are just some highlights that we did last year. When we met last year, when you all met last year, we met in August or September, and the mudslide had happened in late July, August time frame. But here's the numbers that basically, that big mudslide that came down on Highway 133, of the tonnage and the yards that were moved. And pretty big winter last year. I'll just let you read through it. I don't want to go through each one, but to kind of answer your question earlier that you brought up about the surfacing of Maroon Creek Bridge and the ruts, as you heard, maintenance, the commission is trying to hold us harmless or leave us with as much money as possible, and that's great. What we try to get across in these kind of meetings is that because there's no engineering money, basically, the maintenance money has to stretch further to do like the ruts everywhere. And so we try to get to those things as soon as we possibly can. But even though our money's mostly been held the same, it's going a lot further to try to hold the roads in as good a shape as possible. So we may see more of that type thing where there's rutting. I know that Brian from Pickens County and I had a conversation about the ruts on Highway 82. It's kind of rutting all the way through there, and it's the same all over the region. So we're just, in maintenance, we do our very best to try to pick the worst spots and hold them together the best we can. So anytime you guys can point out something that we can put on our radar, we'll certainly try to get to it.
Yeah, my understanding about the ruts, it really, and they're everywhere, I agree with you. It's really the intersection of the ruts and the steel joints that are problematical for someone driving a car.
Steel approaches.
Yeah, as you slam into it, and that's a kind of a different phenomenon than just rutting.
Right. Unless it's a hard rain, and then that's a really big problem everywhere.
Yeah, I don't know. I'm not asking you to solve all the rutting problems. It's just this is.
I was looking at that, and we've been trying some different things on the joints to try to not have to make a huge repair, but possibly do some different materials to make them to where you don't get those.
Right, just to soften the approach. To build on this deck sealing, the epoxy seal we've done, the Maroon Creek wasn't the first. We've done it on the silt bridges on the interstate. We're getting ready to do it out west of Grand Junction, and I really like it. I really like the process. I think we're getting better longevity out of the surface, and it's less of a maintenance issue for us. So, research is still there, but I think we're doing good.
Yeah, I mean, it's a stupendous bridge, and I just hate to see it age prematurely. So.
No, we'll have to, if it's first to wear out, we'll have to reseal it.
Yeah, well, I just want to mention that at one of our most recent CCI meetings, Colorado County saying they're preparing their legislative agenda for the next year. And Commissioner Runyon had submitted from behalf of Eagle County that CCI should back the legislature putting forward some sort of 25-cent or more gasoline tax increase, and a second resolution supporting a vehicle mile travel type of program to augment what we know is declining revenues with all-electric plug-in cars, so on and so forth. And the dialogue was interesting to me, but by a number of advocates of transportation, it's like, yes, it's time, let's get it ready for 2012, whatever. The others were comments of, well, if we could just get rid of all the off-the-top skimming from the fund, or if we could stop being so administrative, top-heavy, and there's all sorts of waste, and, I know that's been the battle cry for not increasing the funding for decades, and I've watched various directors who really did a good job at trimming and improving processes, where I don't believe there's that much left. Then the argument falls back to, well, if there wasn't so much time spent on permitting and NEPA and safety, and I just don't know if there's something that, and this is more to take higher up the scale than to answer now, but that helps respond to those questions so that we can get people to realize that you're just not going to cut your way into solving the fact that we're putting 1/4 as much money as we should into maintenance alone, let alone capital, the surface treatments. But there seems to be that those arguments have a life of their own, and I never feel like I have the facts to help defend this.
Well, I think there's always that perception. I think you've probably all heard Governor Hickenlooper, since he took office, talk about trying to make sure that state government is operating as efficiently as it can, and
we all support that.
I've served under now, he's the fourth governor, the fourth executive director that I've served under, and I think they've all worked in their own way to address that, and I personally agree with you. I'm not saying there aren't things that CDOT could do better. There are, and Don Hunt is very committed to continuing that effort. But I think what you're talking about now is sort of small improvements around the margin, but you're never, through efficiency, going to address the funding gap. Because we're talking about billions and billions of dollars, and I think you might be talking about a few $1 million in aggregate as some of these efficiency initiatives work their way through the system. As to the off the top, if you look at that pie chart on the bottom of page 8, you can see that the off the top is now about 11% of the total HUTF. And that's the money that goes primarily to fund the state patrol. Some of that goes to the Department of Revenue as well. And I think everybody would agree the state patrol is a very important public service. But, over the years, the legislature has chosen to do it this way. And of course, to try to take that back into the general fund to the tune of $100 million to free up that money for roads just isn't in the cards right now because of the pressure they've got on the general fund. But the challenge with that off the top is it continues to grow every year. The legislature has grown that somewhere between 3% and 6% consistently over the years. So as the total HUTF pie doesn't get bigger, and in fact maybe gets slightly smaller each year, and that off the top to fund the state patrol keeps going up 3 to 4 to 5 to 6% every year, it's just going to become a bigger and bigger piece of the pie over time. And you can see right now the allocation to the off the top is almost as much as the cities get out of the HUTF. So it is a challenge. But I can tell you, I think Don Hunt and the commission are committed to continue to work to make the department as efficient as possible. But I don't think we can cut and make this up just through efficiency. We can do some small incremental things, but at the end of the day, there's just not enough revenue to do what needs to be done, in my opinion.
I did inadvertently skip rolling. There's an engineering section. Well, we hit on a lot of these projects. Anything specific that you'd like to add, or something that's coming up that you want to let them know about in our engineering section?
No, most of our Highway 82 and Pickett County projects have been completed for the year. We did some safety rehab improvements to the Maroon Creek Bridge this spring. We've got a culvert repair up on McClure Pass we're doing next year. We've got a resurfacing project on Highway 82 next year from Snowmass Canyon up to Aspen, but that's about it for engineering projects.
Okay. What is a composite blanket?
Compost.
Oh, compost. Good. Okay. Thank you.
George?
Back to the funding question, Commissioner. A lot of our interstate system throughout the country are toll roads. Is that an option that you are looking at for the future for I-70 specifically?
Yes. We have an enterprise within CDOT called the High Performance Transportation Enterprise, and I'm one of the commission-designated board members on that. And I think that tolling is something that we're going to have to look at very hard in this state, both as it relates to tolling to pay for new capacity and possibly considering tolling existing roads as a way to provide the dollars that are going to be needed for the long-term maintenance. I mean, you know, the interstate system is getting, depending on what part of the interstate, there are parts of the interstate system in this country that are 50, 60 years old and are just wearing out, and so a lot of the, you're not really talking about just resurfacing anymore. And I was just traveling in Montana and Canada and the Northwest the last month or so, and for example, in the state of Oregon, there are major sections of Interstate 82 and 84 up there that they are totally reconstructing because it's just worn out in areas that are very heavy truck routes up there. So I think tolling is something that we're going to have to look at, and it's very much a user pay. And when I was involved with Governor Ritter's Blue Ribbon panel, we talked about that an awful lot in terms of the philosophy of how we ought to pay for our transportation infrastructure. Clearly, the motor fuel tax over the last 50, 60 years, however long we've been using it, is very much a user pay system. Tolls are very much a user pay system, and I think that is definitely something that we're going to have to look at as another way to help pay for especially new capacity and multimodal type projects.
Thanks. Thank you. We're just about time, but we have a little more if you'd like to make some comments.
Last time we came up, I tried to make some notes of things you asked, and I swore I wasn't going to go to a county meeting without answering questions from last year. So, someone asked about Ewan Underpass. I believe that was, they asked, is this a CDOT project? We did do that project, if I understand. We're doing an IGA to turn that over to the City of DeSalt. And I don't think that IGA is complete yet, right? Or we're in process?
It's in their hands, waiting for signatures.
It was a CDOT improvement, we're giving that to the city. Commissioner, you've asked, I know our county meeting and Intermountain TPR about VMT in Oregon. Mark, our planner, looked around and got this PowerPoint presentation. Their pilot program in Oregon on vehicle miles traveled is complete. You can go on their website, Oregon DOT, and they have a whole bunch of stuff. I mean, you can read for days about it. But this is kind of a PowerPoint. I just brought you one copy that you guys can pass around. It kind of highlights some of the accomplishments of their pilot program, some of the deficiencies, things like, how do you best track it? How do you make sure people got the right equipment in their vehicles? And do you do it at the pump? Do you do it once a year? A lot of those details that are still, even Oregon doesn't know. That's kind of what I got out of it. But there's a lot of good information about some of the potential future for VMT. So I brought you that, and
I'm sorry, I made a copy of the book, and that's also an electronic copy, and it's on a DVD that I gave to Bankman. So it's on a CD that I gave to them.
Okay, thank you for that. Do we have any further questions or comments, Michael?
Before you get too depressed, if you look at those two pictures above Rachel, that's the Highway 82 system and the bridge, and there's vast improvement. So don't bum out.
Thanks for all your hard work. We really appreciate it very much. Okay, we'll take just a couple seconds to clean up the room. Let's find the use the restroom real quick, and then we'll go into our interview.
Thanks, everybody. Thank you, guys. You notice the picture on the front of your coat, though? That was one that came through enhancement. Good project.
That's looking really great, isn't it?
That's pretty cool, actually. We told Mark he has to get creative pictures, so that was a fun one, though. That was a really nice one to put on. That was a one, too. Thank you. All right, thank you, guys.
Thank you.
welcome.
It's nice to be here.
Yeah, sorry we're running a little to the hair late.
Well, that's okay.
Okay.
Actually, you're doing pretty darn well.
Today's going pretty good. We want to thank you for service and volunteering for this position, and want to ask, I'll kick it off, why would you like to serve?
Well, I've served on some sort of a commission for the last 30 or 40 years. Haven't just recently thought it's time to get off my butt and do it again. But secondly, I do some mediations, and I thought that this is one that I've got some experience in, this commission, and having been a judge, used to see some conflicts of interest.
Okay, I'm sure your skills would be well received. Other board questions?
Bob's my next door neighbor.
That's right.
Well, it's not he calls himself because I grew in his neighborhood.
No, not at all. But I'm just curious, how did you hear about the position?
Oh, the newspaper.
Oh, the newspaper, okay.
Yeah. I keep an eye on you guys in the newspaper.
Yeah.
I would just thank you for your interest and for applying, even though this is hopefully not a committee that has to meet very often. It's a committee that is important to have, and to have someone with your background and interests is certainly appreciated.
Sure.
Yeah, John, Ely, do you know when this commission might have met last?
I think you might have asked me that not too long ago. I probably guessed, and I don't want to sound stupid by guessing differently this time, so...
Just during the BOCC application,
Oh, okay.
Shelley, Roy, McIreland, and myself got called on the carpet for having a conflict relative to either comments made about a future application, or I was just running for election, so all of us were easily found NA not applicable.
And so that was 12, 11, and...
It was about 11, 10 plus years ago, so may I have a follow-up question?
Please, go ahead.
Do you mind serving on board that hopefully we don't have very active members on?
That's one of the reasons I applied. No.
Yeah, so in all seriousness, how would you define a conflict of interest?
Well, I think you have to look at each individual situation to be able to figure out what's a conflict of interest. You can go through the statutes and they can give you some idea what a conflict of interest is, but they're not very helpful. I think it's purely, in my experience, you just have to look at each situation and try to decide whether there really is a conflict.
We have obviously statute, as you just mentioned, but we also have a policy on code of conduct, as it were. So within the body of that work, there's reference to conflict. So that if you happen to be appointed here, you might review that.
Sure.
How about perceived conflict of interest? There's a difference between a direct and a perceived. Could you address that?
I've already dealt with direct conflicts of interest in the past. I guess perceived, if I understand the term, is what somebody thinks is a conflict of interest. And you have to sort that out to see whether that's true.
Good, thank you.
Michael, then Rob.
Bob, thanks for being on this. This is going to be a soft re-entry into public service. But let me ask John. John, so this board meets, a member of the public says there's a conflict of interest, and can they say, I would like a resolution of this, my perception, by this board?
Yes.
And then the board meets and goes through definitions, statutes, whatever, and comes up with a conclusion.
That's correct.
What then?
Then it is the conclusion or the decision of the conflict board is communicated back to the Board of County Commissioners as well as the party that brought up the issue in the first place, and hopefully that resolves the issue. If it doesn't, there are other forms available, but we have never gone beyond the conflict resolution committee.
So say the board finds there's a conflict of interest with a commissioner. The board actually can't ask him to step down or to recuse himself, can it?
That's correct.
So what then is the process?
When that particular item is before the Board of County Commissioner, that particular commissioner excuse himself from the debate, from the participation in any vote.
Is there any force of law behind that?
Well, what it does is it sets up a method of the conduct of the commission as a whole. So if somebody is just flat out obstinate, then their action isn't recorded as part of the minutes anyway. So the board's action would go forward. The board isn't held up.
So the person can participate with this conflict adjudicated, or I don't even know how you'd phrase it, conflict of interest, and the board goes ahead and that is not part of the vote, or that person doesn't?
I can't even envision somebody doing that, but so if it happened, it just that person's vote would be recorded.
Would be recorded.
Would not be recorded.
Would not be recorded. Interesting. So the conflict of interest board seems to lead to a resolution, and yet after that it gets more complicated.
Well, I wouldn't think it would get more complicated. I would think that anybody with a potential conflict of interest that has had it examined by the conflict board will invariably take the recommendation of that conflict board to heart and go forward based on that. I can't imagine a circumstance where we wouldn't have a regular resolution for whatever the matter is in front of the board.
No, I'm just asking the question just as a hypothetical, and I would have trouble imagining it also, but my imagination only goes so far. So.
I would assume it's doable.
Next door.
Yeah.
Bob, do you have any? Oh, Rob was sorry.
Bob, thanks for stepping up. Sure. Hopefully we won't need your services all that much, of course. What sort of advice would you give a new commissioner? I've stepped up a bunch of times saying, well, this person's a good client in my restaurant, and this, and obviously it's a small community. We all know a lot of people that come up in front of us as the Board of County Commissioners. What sort of advice would you give a new commissioner in terms of avoiding your services?
I think that's the same situation that a judge runs into all the time, too, because almost everybody, as the county judge comes before you, especially 10, 15 years ago when the county was even smaller. I'd say you have to live with your own decision on that sort of thing. If you think that it would affect your decision, then I'd recuse myself. If you don't think it would affect your decision, then you don't have to.
Thank you.
Sure. And do you have any questions for us?
What's the pay?
Well, there is a volunteer party 23rd at 5 p.m. There's one once a year, so I try to get all the crackers and snacks that you can. It's the 23rd, so we may not have...
What I'm going to suggest is we'll bring some of our stuff. We're doing a beverage made from wine grapes that have never been fermented, so zero alcohol, but all the antioxidants and health benefits. We'll donate some.
Oh, well, that's a good way to get appointments. Well, very good. And I don't think we'll have time to have formally done the appointment before then, but take it as a chair's invitation to attend if you'd like to, and start to meet some of your fellow board members or whatever, since they're not there that often. And,
One question, who are the other board members?
let's see, I was just looking at that. It's Michael Kinsley,
Al Dieter.
Al Dieter. And Neil Siegel.
What Peterson?
So people you'll know and who we're working with. So again, thank you for your time.
Sure.
Appreciate it. Okay. Well, we're pretty much back on schedule now, and we're now scheduled to have an update on the Aspen Area Community Plan with Cindy Hoogan and Ellen Sasano.
You guys use it.
Oh, you know what, we're not. I don't think we are. Okay. So, okay.
Are you ready? Yes, please. Just introduce yourselves for the cameras. And
Great. Ellen Sasano, Senior Long Range Planner. Cindy Hubin, Community Development Director. And we have, as you know, we have both been working with both the City of Aspen Planning and Zoning Commission and the Picken County Planning and Zoning Commission in an endeavor that's been going on for a little over 2 years now, maybe 2.5 years, to adopt an update of the Aspen Area Community Plan. And this is updating the last plan, which was completed in 2000. And we just wanted to give you an update on where we are in terms of progress and process. And the planning commissions have been meeting more than regularly, as much as two to even 3 times a week to try to get this plan completed. And
Bert Warren can't get enough. He's with the city P&Z, and we thank him for being here.
Yeah.
Thank you.
And let's see, we last came to you in February with an update, so it's been a while. And as you know, the memorandum we put together provides an update on some of the issues that were raised by you in February and how those issues have evolved over the last several months. And the planning commissions are still preparing a final draft. So even at the date when we drafted this memo last week, things were evolving and changing, and we've met actually twice since the memo came out with the planning commissions last week. So some of these issues have actually, the status of them have changed a little bit since the memo was drafted. But so we wanted to give you an opportunity to talk to us about any issues that you may have and to go over some of the issues in the memo if you'd like. And also wanted to just talk about the final, coming up to the final adoption. And I'll start with that if that's okay. And Cindy will jump in as maybe. We are looking at, hoping to have the Aspen Area Community Plan adopted by the County Planning Commission. We're hoping for sometime towards the end of September, 4 or 5 more meetings. And we also assume that at that point that the City Planning and Zoning Commission will recommend adoption of the plan to the City Council, and it will then move on to City Council for final adoption in the city. Once the County Planning Commission has adopted the plan, as they will authorized by state statute, they will then, we will bring it to you for ratification. And so we actually talked on last Thursday with the planning commissions about the fact that ideally we'd like to not get to the end of this process with 2 different Aspen Area community plans, one adopted in the city and one adopted in the county, given that our adoption procedures are a little bit different. And the County Planning Commission said, you know what, we really don't want to change the adoption procedure that we've used historically. We would like to complete our work on this plan and adopt it as we can by state statute, and then pass it on to the Board of County Commissioners for ratification. Understanding that it will then go on the city side to City Council and may change. It's conceivable that City Council will adopt the same plan that their Planning Commission recommends, or in the alternative, they may actually adopt the exact same plan, which would be kind of a simple outcome.
We could have, excuse me, but I think we looked at slicing it so many different ways. And the planning commissions just said, you know what, we want to adopt the same plan together as planning commissions because we've been doing this for 2.5 years together and we feel like that's the way to go. And if in fact there are changes by the city council or requests for changes by the board, we'll deal with them at that time, rather than try to say who's on first when. Let's move forward in that direction. And so our hope in this discussion today, in bringing you up to speed on some of the main issues, is that we can in fact get some of your feedback, if you have any, on any of these primary issues. Once again, take those back to the P&Z for them to hear. They feel that they have heard you throughout the process on some of the primary topic areas and have made substantial changes. As Ellen said, we don't know what the outcome might be when it gets to City Council. And so I think we have some decision points at that time to say whether or not you would like to sit in with the City Council when they deliberate the plan and hear some of the discussion and determine whether or not you would have things you would like to also have the P&Z look at again. It's just a little more awkward than it used to be in the past when we all adopted together. Before the city was, I think, looking at their ordinance in a way that would prevent them from having the city P&Z adopt the plan, which is how we had done it in the past. And then we would always come jointly for ratification prior to the final adoption for a draft ratification from the board. But I think the P&Z was pretty clear with us on Thursday night that they just want to go ahead jointly with the city P&Z and make a recommendation. They would like to adopt, and the city P&Z make a recommendation to the council.
What happens if the BOCC did not adopt? I mean, does that just send it? Did not ratify?
Does not ratify. Well, that's obviously a situation we don't want to see happen because then you would not implement the plan. Yeah. It's up to you ultimately to make the decisions about implementation that require changes to our codes. And so if there was something that you didn't agree with, we would hope that you'd have that conversation with the P&Z and work on that together to revise the plan in a way that could be worked out. But ultimately, you have the authority to implement.
I just, we only have a memo. I looked through the items that you have, identified, and it seems like, they're smoothing out the edges, as it were, on some of these issues. So without the full plan, if I may, the one thing I really have been interested in from the beginning is that we incorporate by reference the vision statements from the previous plans. Is that occurring?
It is starting to occur.
It's starting to occur? Is it going to be an appendix to the document or not? I mean, that's the one thing I've asked for, is that they be moved forward, that we don't lose the history of the evolution of the plan and the statement of intent. And, it's kind of like taking a perfectly good mission statement and then saying, okay, we have to wordsmith it to make it a new mission statement. But you shouldn't lose what the old mission statements were. And I just know all the work that went into 93 adoption, all the work that went into 2000 adoption, and, since our very first meeting, I've asked that we see that, and that be part of the plan.
And I think that what is happening is there's revision actually in the plan rather than just reference to the plan in many cases.
So it's actually including them, again, as an appendix or something, but I think that should be there.
They have not included them as an appendix. We'll bring that up again, but a lot of the mission statements now are being brought forward in part, or in some cases, I think one in full, where that is the mission statement from the 2000 plan.
Or the vision statement.
The vision statement from the 2000 plan. But there has not been any reference by appendix. I'm not really sure that people understood that you wanted them referenced by appendix, but you did want them referenced and brought forward in the plan.
Yeah. And Bert, actually, to his credit, since he's here, Bert has been very, very diligent about always checking back to both plans, and he has been responsible for bringing several of the vision statements from the prior plans into the current plan. I won't speak for him, but you're right, you have specifically asked that these be brought forward as an appendix, and we just haven't gotten to the point where we've gotten our appendices defined to that point. So, yes, they have been, several of them have been incorporated, but no, not all of them have been incorporated, and we haven't, I don't know that we've even specifically asked the P&Zs to incorporate them as an appendix, but you have over and over requested that, and we will take it.
I mean, it's, to me, one of the single most important things is the continuity of this from plan to plan, and then not trying to have to double-check the wordsmithing of the new vision statement to see if you can read between the lines to say it's negating a previous goal or not, that those goals live on in their own way. We didn't scratch them off and just say, oh, that's done, and, the critical mass of affordable housing is not significant anymore as long as we have a given number or something like that. So I'll let that go and see if other board members have questions or want to talk about these specific items, or were you planning on walking us through all 12 points?
Which I'd just like to be really clear before we do move on, that in some cases, the direction from the P&Z may have changed.
Yeah.
And so we'll be as clear as we can.
Yeah, maybe that presentation that points out those differences is going to be the most important part. What's different with the plan that really countermands or takes away a direction, that negates previous directions. So anyhow, if other people have questions, I'll go check in on this stuff. Go ahead, Michael.
I'm less concerned about, real referencing as much as just might have it in the appendix as a historical reference. I mean, in 1993, my daughter was 13 years old, and now she's 31. At 13, she wasn't thinking about having children, but now she is thinking about having children. In fact, she's pregnant for the third time. So, I can allow for a difference in vision given the number of years. And I can actually allow for change. And a document that doesn't allow for change is not a particularly good document, but I think it should reference change.
So, sorry, may I clarify then? So, literally attaching the vision statements from the 93 and 2000 plans as an appendix would be an acceptable outcome. Just
well, I mean, we have 5 people, they might have 5 different opinions. I'm just trying to give you mine. I'm not trying to summarize the opinions of other people here. But I think, if it is a document that arises out of those past documents, there's no reason not to have those documents attached in some form.
Jack, what's up? Michael, you got to take over.
No, you, Michael. I think we should just be on our own. Jack, you want to talk? Don't ask me. Just do it. Just start screaming. Okay. Well, probably won't do that, but question, I guess, specific question and then more of a statement. On item 6, the last sentence says, and this is about 100% mitigation, the last sentence says, there's direction, and I'm assuming direction from P&Zs.
Correct.
To analyze the scope of development impacts on community infrastructure and to determine to what extent public subsidies may be acceptable under circumstances where development provides community benefit. Somebody out of their mind making that statement? Since when do we subsidize development? Now, I'm not talking about an affordable housing project because that's a different world. I'm inferring this is free market development.
I think the term subsidy maybe it's used broadly here. It's saying that if someone isn't required to pay their full, pay mitigation for full impacts of the proposed development or the development, then in effect, there is a public subsidy.
You mean the public would backfill? Is that what we're...
Yeah, the public's picking up the cost
of the affordable housing mitigation or whatever the developer hasn't had to mitigate fully, because there's some public benefit to balance out that subsidy, the public cost, if you will. That there's a public cost, and subsidy is just another word for that. Does that make more sense?
Well, no, I'm glad, we're having this explanation. Is there strong support for this concept on the P&Zs? Is it divided? I mean, it's just a concept that doesn't set well with me, because it could be abused. It's recognizing the fact that, our code doesn't allow 100%, for example, road impact fees. It has to go with whatever we passed 5 years ago, whatever that was. But this is, stating something where developers, being experts at what they do, will find a way to wiggle in here and offload or, responsibility.
The debate, there has been quite a bit of debate, again, Bruce here, and just quietly listening, but there's been quite a bit of debate on this subject, and there are some planning commission members who believe that development should pay for 100% of its mitigation and offset
100% of what the code requires.
all of its impacts in the city and the county. Basically pay for all of its impacts. There are others who acknowledge that, well, in some cases, there may be some public benefit in the form of, or perhaps there's some affordable housing that is a benefit or a different type of public benefit, like a park or open space or what have you. And under those circumstances, there should be some balance and some acknowledgement that, okay, so the public is benefiting in some sense, so perhaps we need to back off on the full mitigation that would normally be required.
So the comp plan, is the comp plan stating that there is an ability, given there's public benefits, for a developer to mitigate less than his fair share? I mean, is there an active state?
potentially, and it depends on what you're calling development. There could be a nonprofit group that we totally support the community and that could not supply 100% affordable housing for their staff, something like that. Staff needs, where the community might find, I'm just using an example, community might find that it's more of a benefit for the community at this point in time to have that nonprofit active in the community, rather than say, sorry, you can't construct the space that you need or develop the project that you might want to see. And the idea behind this, Jack, is not that this is just something that's carte blanche and it's just going to be left out there without any definition. The concept behind this is that we would explore code amendments, and all those code amendments would have to come forward, obviously, to the Planning Commission and then to the Board of County Commissioners to say, this is the appropriate time at which we might say full mitigation is not required.
There may be some exceptions.
So all of that is going to be explored to the nth degree when we do our code amendments.
Yeah, and I appreciate the example, for example, the nonprofit, because then I was thinking of, for example, the county government. And we rebuild an office building some century. And we have a huge mitigation, affordable housing mitigation. Are we then saying we might suggest we could let ourselves off the hook? So that's an evolving conversation, but it's somewhat disturbing because I'm just not, I've not ever thought of public subsidies being defined in this way it's more of a passive subsidy as it were than an active, you know.
You can also see subsidies in the case of upzonings. You know, if we decide a piece of property is appropriate for affordable housing and more density, in a sense, that's a public subsidy because we're allowing that density to be placed on a property that didn't have that zoning before. So there's all kinds of ways to look at it.
And subsidy may be too broad a term.
Or maybe, yeah, it could be clarified. I have a project in Somass Village that was an upzoning. We could really provide a public benefit for Base Village. Anyway, okay, so my last thing is, on the adoption piece, you know, I can see that there's a sense by both commissions as well as staff to adopt the same plan. But the mechanics of the use of the plan is going to be quite different in certain areas. You know, not like livable communities, for example, but land use, for example, and urban growth boundaries and, you know, those kind of things. So what I'm hearing is that not only do we spend some very well appreciated time by both P&Zs for 2.5 years and staff, and appreciated P&Z time, I had to say that twice, because these are volunteers, but then we are actually, as a county, going to need to sift through the comp plan and create code language. This is somewhat troublesome only in the fact that this is a 5-year deal. So, oh well. Yeah, I go back to my comments as quoted in the Aspen Times where, you know, I would have liked to have a joint plan where we joined and a separate plan where we didn't. But we are here now, you know, a joint plan where there's commonalities and separate plans when they're specific, like this whole west of Castle Creek thing. We still got to do a sub-plan there, and to me, that's disturbing also because it's just more and more and more. You know, thank God we have such a proficient or experienced planning staff because this is some lifetime work here, it seems like. So, anyway, thank you.
Michael?
Yeah, I'm less concerned about it. You know, I view it really as a touchstone document, as something that we can refer to, and it gives an historical basis for why we might make decisions in the future. And you know, I'm just not that concerned about it. And in terms of planning, that's what we're here for.
George, or then Rob?
No problem, go for it.
Rob?
My comment, and which revolves into a question about the AACP developing into code, has been a reoccurring theme of me and what people have conveyed to me to convey in various meetings I've been through the process in terms of the language that's used in the Aspen Area Community Plan. The question's going to be, you know, talk about the process of how the AACP turns into code. The comment is what's been conveyed to me and what I've tried to convey to the Planning and Zoning Commissions throughout this long process is that the language is very strong and we want this document to have some sort of teeth. I've heard that from several P&Z commissioners. Yet at the same time, you know, this juxtaposed idea of is it regulatory or is it not regulatory, there's a huge fear out there that someone's going to look at one of these items and say, well, we've already stated it in the AACP, so now let's just make it law. So it's one step closer as opposed to going through that full vetting process. You know, I've spoken up many times in front of the P&Z commissions and said, you know, you have to say that these are ideas and thoughts and goals and that they are, you know, they may or may not be implemented into code. And, you know, I read through several chapters. I didn't read through the whole thing last night and this weekend, but I read through several chapters to get an idea of where that's gone, and I still have that concern. I still have the concern that when either the city council, and I believe this is a joint document, so I believe I'm concerned with how they treat it as well as how we treat it, whether it's the city council or whether it's this board, how we take this as law when we are creating laws or codes, as opposed to, all right, these were good suggestions that came from various bodies of work. It may not, they have to be fully vetted then. So I guess if you could answer the question about how the process goes from implementing this plan into code and reassuring us and the public that things will be fully vetted then as well, individually, as opposed to an 80-page document, and why the language is so strong in this document saying, this is what we want to do, or, as opposed to, we think this is a good idea, let's research the code aspect to this, or...
Well, to be very specific, if you look at the plan, there are 7 different ways to implement, if you will, one of the action items, or what is going to be called the recommendations, considerations or recommendations. We haven't come up with the exact term yet, rather than action items. But there are different ways that the policies are looked at, and they're looked at either as, broadly community goals, just we would like people to take into consideration our overall goals when you're looking at a development in the community, or if you're looking at any change in the community. There's also collaborative initiatives where it's not always going to be government making decisions, but we're putting it out there. This is something that community can look at together. Like I said before, there are many nonprofits that work on many things that are all about our community and how that pulls together. There are potentially some incentive programs that look at how can we look at our regulations to incentivize certain things at certain times. And again, that might be looking at voluntary programs for incentives as well. There are the work programs that might be just potential departmental work programs that may come out of this type of direction. And they don't necessarily have to change the code to be worked on, because they've been envisioned here as something that's good for the community. There are data needs, things that we just don't have information about, so we'd like to gather more data on. And then there's also proposed code amendments, and that's what gets into what we talked about a second ago. If there's something in here that talks about a direction or a change or something to be explored, oftentimes that might come up in the form of a code amendment. It may be that we have to bring something to you to say, our land use code just isn't sufficiently handling what needs to be done to implement a vision or a goal or a policy in this plan, and therefore we need a code amendment. And the example of the 100% mitigation or full mitigation is a great example of that. If the direction stands that, in fact, in most cases there'll be full mitigation, but there are exceptions to full mitigation, we have to look at that and determine through a code amendment really where that's appropriate to have exceptions to 100% mitigation. So I think there are certain statements that are regulatory in nature, but if it's regulatory, at least it's already regulatory. Go ahead.
I just want to add that our comprehensive plans have historically been used in this way. If it, by reference through the land use code, in a particular kind of land use review, say a special review, if there is reference in that special review criteria to a requirement for compliance with or compatibility with the applicable comprehensive plan, then via that reference in the land use code, the Planning Commission and or Board of County Commissioner may use the comprehensive plan in decision-making in review of a project that's subject to that specific kind of review that's referencing.
And the land use code calls that out today.
Right. So
may or may not rezone a property unless you reference, the comprehensive plan and what it tells you in terms of the direction.
And that has historically been how comprehensive plans have been used in the county, and that is how we contemplate this plan being used as we move forward. That said, we've got some more specific direction about how each policy is intended to be used in the ACP, and that is really more directed to the city use of the plan because they have a slightly different approach to how comprehensive plans may or may not be used in regulatory decisions. So I want to make that clear that we are going to continue to use this comprehensive plan as we have others in the past by reference in the land use code. It may be used as a regulatory document.
I encourage you to go through that.
I think that historically, just in the past 2 years, 2.5 years before you got on the board, when we were starting this process and kicking it off, as a board, with different members, obviously, but our direction to our staff and through to our P&Z was that we wanted to see this question of regulatory versus advisory settled towards the regulatory side. That's very protective of citizens. If citizens buy property and everywhere next to it's supposed to be outside the urban growth boundary, they don't want to see us coming in and saying we've decided to make a new industrial zone because we have a new board and we could just throw away the work of the community plan or all the money spent in developing the community plan. There's always got to be conflicts in the plan, and people will have to hold up the parts that support their individual decision on any given application. There's no way to entirely, or ever has been, as far as I understand, reconcile all the different values because it's a document that tries to encompass the whole pool of values that are out there, and sometimes some have a more overriding purpose in a given proposal than others. But our direction as a board was that we wanted to see this maintained as regulatory and be something that people could depend on for protecting their community interests and community character. I think that's a lot of why the public has supported, and the results that we have achieved over the past 2 years have been consistent with that as well in the urban area. Ellen has a comment to follow up on that, and then Michael.
As a standalone document, the comprehensive plan is advisory, but where it's used in conjunction with the land use code and reference, then it may be regulatory. Just one last clarification. Thank you.
Thank you. Michael?
Yeah, that's what I was going to try to clarify. I actually, in my 6 years' experience, have not come across a conflict, ever, with the Aspen Area Community Plan and our code. Just never. So in terms of a county document, we just don't use it as that kind of bludgeon. We just don't do. And, it guides, I think, our code. When we have a code change, it guides that, definitely. But I just haven't seen where, and I don't know what the references in previous Aspen Area community plans, but when we went through a thorough code change in 2006, my guess is that a lot of those, at least like water protection, that kind of thing, led to setbacks, larger setbacks within the county. And that became a regulatory code. But the Aspen Area Community Plan might have only pointed us in that direction. I've never used it and said, well, this contradicts the Aspen Area Master Plan, so I'm not going to do this. It just hasn't happened as a practical matter.
George?
I have a question back on one of Jack's points early on item number 6. Just to clarify again for me, and maybe this was a long discussion as well in terms of the 100% mitigation. Was that conversation stemming from the discussion on the percentage of affordable housing that should be required for development? Because I know that's where there was a lot of discourse.
Yes. Right.
So instead of saying that this plan will require X percentage of affordable housing to mitigate a development plan, it's a little more open-ended, the way I read it. But then my question or my point is, I'm not sure how you're going to determine that, because I think, as we know, that no development ever pays its way. And sort of stats that I've read, for every dollar of taxes garnered from a development, the cost to the community is $1.25, $1.35 and up, because of the impacts: schools, roads, health and human services, public safety. So even, I understand that the P&Zs could not, perhaps they just could not come to an agreement or consensus in terms of what mitigation should be for affordable housing. This seems to be so broad that I'm not sure how we would address it to have some sort of consistency versus case by case, and we're just kind of throwing out ideas and seeing what the developer will throw into the pot.
Well, again, this is the visionary document, if you will, in that regard. Your code is still the same. County requires 100% affordable housing mitigation. The city requires 60% affordable housing mitigation. Those formulas are different formulas, and the actual numbers that come out of that are different. You can cut this so many different ways in terms of what that ultimately is, but ultimately that decision is going to be yours, and you're going to have a study in front of you, and you're going to have a code amendment in front of you to make a decision about whether or not you want to go in the direction that the plan is pointing us. Basically, they're saying, we think that there should be full mitigation for whatever, however that comes about. We think that there should be full mitigation for much of the development that happens in the community. However, there are exceptions. There are things that we feel might have public benefit that would require less than full mitigation. And so whatever that might be would have to meet your test to make that determination.
And we, as Michael says, a lot of this we currently do with our codes through the GMQS process, and if we're going to issue TDRs, what sort of, or extending vesting rights, what sort of community benefit is going to happen. So, all right, it was just...
Yeah, it's the vision, and it has to come back down to the code level if any changes are going to take place.
Two other comments or questions. On number 8, and I'm sure there was, again, a lot of debate in terms of coming up with some wordsmithing. Modest, the question was, the plan call for development that is modest in mass and size and scale as it relates to existing neighborhoods and character. And the term was perceived by some as difficult to define, so the P&Zs actually added modest and respectful. Again, that's so, to me, so subjective. What's respectful for one person is offensive to another. So it's more of a wordsmith thing. I understand where you're trying to get to, but I wonder if there's a better way to...
Not boastful or ostentatious?
A better term. I understand that, but for me, it still leaves a lot to the imagination. Just a comment. And lastly, just in terms of the process, back in the last item, number 12, will we see I'm assuming we'll see a final copy before it actually goes to our P&Z for adoption, so that if we have any last-minute tweaks we want to add to present to them, or what are you, or what are they anticipating in terms of that process then?
As we know it today, initially we wanted to have a joint meeting with everybody, the two P&Zs, the council, the board, everyone get together and go over the final draft together. I think the P&Z's direction at this point is they're holding their public hearings, they're going through the process now. There will be a new draft out for the public to see here in the not-too-distant future, when you think at end of September, or hopefully mid to end of September, a draft for the public to see. And at that time, there'll be additional comments, and people will come to the P&Z meeting and make their comments, and the P&Z will determine what changes, if any, they'll make. If the board is requesting an additional meeting with P&Z, I'm happy to take that back to them and tell them that you'd like to do that. But at this point, I don't think that they have contemplated scheduling any additional meetings with the board.
Yeah, I'm just kind of curious in terms of the process. After you give public comments, and actually, I thought what you said earlier was that we would hope that we would have the final document ready for adoption by the end of September. So, but if we're just doing a draft by the end of September and then still looking for public comment, I'm more concerned that we're going to continue to be pushing that time frame out.
Most of the chapters have been redrafted, and the introduction and the introduction, linkages, a couple of the action items, linkages and introductions still have to be redrafted and then consolidated into one document. We're reviewing them all at the same time right now. So hopefully, within the next couple of weeks, there'll be one document that the P&Z will agree is their final draft.
And I think the planning commissions are, their intention is to, the county planning commission's intention is to adopt by the end of September. That's the goal. It could change. And I think that the city planning commission's goal is similar, that they would like to pass along a recommendation to the city council at the same time. So that's the intention.
What I just heard you say was that you're hoping that by the end of September there will be a final draft that will be presented, but then we'll still be open to public comments, which to me means it's not going to be the final draft in this community. I mean, it could just go on forever.
We have been holding public hearings, and we've honestly, attendance has been very lackluster, to put it mildly. But we have had, I don't know, 6, 10 public hearings, and the intention really was to try to get public input as we went through the public hearing process, and we've made attempts to do that, and I think that the Planning Commission feels as, if I may speak for them, which is, I probably shouldn't, feels as though they've made the effort to include the public. This document's been published on our webpage. We could probably always do more to try to involve the public. It's a tough nut to crack, but I'm thinking that they are feeling as though, okay, we've done this, we've attempted to involve the public, and to some extent we've gotten some great input along the way for those who have been involved. And I believe that they're hoping to have this thing adopted by the end of September.
So I guess I'm just curious what the other board members think. I don't have too much of a problem, but I will see the final draft, and perhaps if there's anything that we want to discuss amongst ourselves, we can discuss with staff versus having the P&Z to have to come in. I'm not sure that there's going to be anything very significant, but I was just trying to understand the process, how that works.
Yeah, for me, George, I think it's the terms draft, We're getting real close to, it should be really considered a final draft at this point, not just a draft or a preliminary draft. And so to get final comments on the final draft, see if there's any revisions, and start holding hearings on the document. And it's no longer a draft. I think that's the real question, is when do you stop calling it a draft, and this is the document we're taking comments on. There's always a chance that there will be a line stricken or changed or inserted or something at that point. But we're moving along from draft phase to review of the final document, and maybe that needs a little clarification as we're discussing it.
So where exactly, online, there's a draft that's dated August 15th, yesterday. So, where is that? You say there's another draft being done now, or is this the final draft?
That one's not totally, that's the final draft of many of the chapters, but it's not the complete document.
That's the final draft I believe, of all of the chapters, but there are other elements in the plan that have not been completed.
The introduction, the action items, and the linkages.
So there's still a couple of chapters that are being updated. This is a 117-page document under one full draft dated yesterday.
It's just posted. That, yeah, so I'm not going to say it won't change at all in the next several meetings that we have, but that is the plan, the most up-to-date plan, and it includes changes that have been made to all of the chapters since the last draft was issued to the public in March. So we're hoping to close in on those last pieces that still have to be worked out, the action items, the introduction, and some discussion of linkages between chapters. That's where we are.
Jack?
Yeah, for me, the key of what I heard relative to George's feedback is P&Z's hope to adopt the final product by the end of September. That's what I want to hear. Because I believe the process has been long, productive, transparent, accessible. You know, we could do this another year and you could continue to get more comment and more and more. But there's got to be a time when you draw the line in the sand, and that to a large extent has to come certainly from your P&Zs, that we are satisfied with this work and we have been accessible and open to comments. And, you know, I mean, with the time this thing has gone like this, up and down as far as public feedback and complaints, etc. So I do hope that's the goal. My last comment relative to this topic, this agenda item, is items 6 and 8. I really hope you have 100% mitigation and development as relates to neighborhood context. For me, those are the two most critical pieces of this memo. And I really hope that you can hone down on clarification of some of the things we've talked about today and mentioned. I don't know if it's by example or explanation or substituting terminology. But this is really open-ended and subjective to a large degree when you talk about modest, respectful, appropriate, compatible. I do understand that word, but the other three is kind of out there for me.
I want to hear clarification on the number 6 item as well. Because again, we just have your synopsis here. Is this going to eliminate the 60% requirement that the city currently has? I realize the codes require what the codes require, and that's a separate item. But, you know, it seems that it might be valuable to have something along the lines of, you know, at least 60% minimum, as a minimum threshold. I mean, because that's been the standard over the past 20 years for affordable housing mitigation. And I would hate to see it become made vague enough that people can interpret it to say, well, on this project 50% is okay, and on this project 40% is okay, and, you know, things that keep inching downward. And so I think that the older 60% standard should at least be a baseline or a minimum threshold of some sort. So, Ellen?
You know, there's been so much debate at the planning commissions on this topic, and we went from 100% mitigation to the term fully offset impacts. And I think ultimately it's going to come down to each jurisdiction looking at their land use codes and deciding whether an amendment or amendments are appropriate, and taking it that next step further to determine what 100% or fully offset means. And that would be my guess as to where it's going to go. But your point is very well taken, and we can bring it back and say, should there at least be a minimum threshold identified?
Or something like that. And again, I just am looking to people potentially using this document 8, 10 years from now, and not necessarily that there's going to be a change in the next 18 months, but I think it's important, and I think back to times more on the city council when projects were coming in with the 60% affordable housing even before we'd adopted the plan, because they knew that's what the direction was. And this seems to offer less direction, and I've seen a lot of things argued as public benefit before. Oh, we're putting a restaurant in, it's going to bring life to this corner of the block. That's a community benefit. We all know the people at the table have to make that decision, but the affordable housing burden is something that creeps well into the whole county for its impacts and things like that. So, George?
I would really support Rachel's suggestion. I think we should have a minimum threshold level. We just met with the town of BOCC over the same topic, and we were beating them up on their thinking that they were going to try to lessen their requirements, and so
to spur business growth or something.
Yeah, so I think we need to have a minimum threshold, and then from there see what else the developer may want to offer to help mitigate.
Yeah.
Because we know they'll never mitigate 100% regardless whatever they say.
I'll go Jack and Michael.
Just about that one. So, Rachel, I can understand the historic context of the 60%, but that's for the city. Is the county there? We have are you talking residential? Are you talking commercial? So wouldn't we say, to try to clarify what you're saying, is as referenced by in the city and county codes or something?
Yeah, I would a little bit want to defer to staff to think about how to handle that difference, because you're right, we say 100% mitigation, but yet our impact fee is so low, it's not enough to create 100% of the units. And at the city level, and we have different, we can think about our code as it applies right outside of BOCC is different than the urban growth boundary, which this plan applies to. Because we don't want all that affordable housing scattered outside the urban growth boundaries, so we've been accepting payment in lieu. Whereas the city almost rarely, if ever, accepts payment in lieu unless it's like a historic structure and it just won't fit in, or they don't want that. And so this is where it gets complicated to use the document for two different parties and but the Aspen area community plans mitigation quote requirement, doesn't extend beyond the boundaries of the Aspen area community plan, A, and then B, because of our mitigation fee, it's probably worked out to be less than the 60% the city requires in actuality and practicality. And that's why when we look at our impact fee, we talked about this not long ago on another application, the fee, if it was applied to try to build a unit, in the urban growth boundaries, is very insufficient. The fee, if it's applied and used to provide a unit in BOCC, might actually accomplish that. And so, I don't know if we can, with our new Nexus study, look at any sort of differential rate or not, or if that's a mistake to even go down that path. But, I really haven't worked out the semantics. I'm just worried about it. If it's left very open-ended, it could be a declining threshold of public benefit that we see over time.
Well, I think that's what George and I were saying. Got to really clean that up.
Yeah.
Thank you.
Okay, Michael?
But I'll go back to the code. The code says 100% mitigation, so I'm not as concerned about it. In terms of of us, and this is really an internal problem of impact fees and mitigation fees and 100%, that we have to reconcile that. I wouldn't expect the plan to reconcile that. There's some difficulties here. And the real difficulty, the fundamental difficulty, seems to me, is doing this jointly. And that has been a difficult challenge. Just because our codes differ, our jurisdictions differ, what we are concerned about is substantially different from what the city is concerned about. And so that's been a hard process to reconcile those differences. And I think we're well on our way to having a plan that's fine, and we'll go from there. But there's a lot of confusion on the part of people, and how does this affect us? And I'm in the county, this is a city, you know, it's been terrible. That's been, I think, the major failure of the effort, and it's added extra work for our P&Zs, significant amount of extra work for our P&Zs.
I agree with that. Although it's hard to see how to do it differently when city residents are county residents, and we have all this unincorporated area around the immediate city. So we'd hate to end up with two contradictory plans that went in opposite directions. So the effort to coordinate is tedious but necessary. Do you have any other things you would want to or needed to point out to us? I think we're just about hitting time here. Or any other board questions or comments?
I was just going to say that just make sure that we got everything. One is, I think you said that you want to see particularly number 6 and number 8 regarding 100% mitigation and development as it relates to neighborhood context. Those terms and directions clarified to the absolute extent that they can be, certainly more than they are now. And also that with respect to mitigation, you'd like to see the planning commissions consider some kind of threshold, a minimum threshold for mitigation. 60% is what the minimum has been, or has been the threshold in the city as an example.
Maybe it's just even a paren reference to historic levels were considered X at a minimum, you know, something like that. I don't know.
And, you know, Rachel, just let me interject. You know, historically, what it was in the previous plan was there was an aspiration to have at least 60% of the workforce housed in Aspen, and that's how it started. And then the code changes start to try to catch up with that vision, and then the idea was you never could catch up to that vision unless you had 100% mitigation, because we have so much to make up for. So it wasn't necessarily that it was 60% as a code. It was 60% overall, over time, as an aspiration.
Great, thank you. And thank you for that clarification. Then we also had that idea, you'd like us to ask the planning commissions if we can schedule some time before adoption to come back to you, or
I think it was more about seeing the final draft that's going to go to public comment.
so at least get it in your hands
Yes.
before the final draft is adopted by planning commission.
And clarify this draft language, but to me, when you've got another draft and they're starting to hold hearings on it, that's the final plan. It's no longer a draft. And when it's adopted, it is the adopted final plan.
Okay.
But that we want to see the plan that they're holding the hearings on for adoption.
And last, you would like, is there an agreement that you'd like to see an appendix that includes the vision statements from the 93 and 2000 plans? Yes?
I think that's good for historical purposes. And again, we always forget that this plan is just, it's not a new plan, it's an updated plan based on previous plans.
It's derivative art.
Okay, thank you. That's all I've got.
A quick comment. I want to compliment staff and the board for requesting a memo form of interaction instead of a joint meeting, and, you know, things, this is way efficient. And really were forced to hit the nail on the head, bring us some items, so I compliment you all and thank you for this.
Thank you.
Thank you. We do have a couple of P&Z members from the city side who took the time to attend. Out of respect, if you'd like to make any comments or amplify any thoughts, please go ahead.
I will.
Okay.
These two ladies are awesome.
Okay,
We're
very
so
good.
fortunate to have them. It's been a long process, but thank you for understanding. And I agree with just about everything you said. You hit the nail on the button.
And you notice he wears his helmet all the time.
He doesn't know who he is.
I'm Bert, Myron for the record, and I think you're on a point. You found the issues that we're concerned about. One of the big things for us is to provide some, avoid jurisdiction shopping for developers. So things look the same if you're right on the edge of the city or the county border, which is really where the ACP regulates. And right now, sometimes that isn't the case. So things come up and no one knows where it is. The other part of continuity is your 100% mitigation for housing. The city is a different number. And if it's fully mitigated, we were trying to get to 100%. We had that for quite a while, and we changed the words. Then it becomes, as you said, then the jurisdiction's option to address what that, how do you get 100%, how do you calculate that? So, and the reason we came to that is no one could determine whether it should be 60, 70, 80, 90, 93, 92, 91. So fully seemed the closest, and then we'll work on trying to, but it makes sense, your minimum threshold.
Thank you for that. And LJ, one last comment.
Yeah, one last, you were talking about the words, we avoided modest for 2.5 years. We couldn't come up with anything. And so they went through this exercise because we were just wasting our time. We just had to come to a conclusion, and we had to pick 2 words. My words were consistent and compatible. Not one person agreed with me on consistent. But I do feel that building in a neighborhood, you need to have something that really is conscious of that neighborhood. So what are the semantics you use, and who knows what we're going to come up in the final? That's it.
Maybe the Citizen's Guide to Planning has some terms or something in their books. I'm sure we're the first town that's dealt with this. Okay, thanks everyone, and we're scheduled for a 15-minute break, so based on that clock, we'll reconvene at 3:35. Thank you. Thanks everybody. Are we all prepared? It's about 3:35 in the afternoon, regular work session of the Pickens County Board of County Commissioners on Tuesday, August 16th. We are going into our memos of interest and going to discuss Veterans Day. Thank you. Just identify yourself for the cameras and we'll go from there.
I'm Jeanette Logan, Human Resources Manager.
Thank you.
You're welcome. So Pickens County and Board of County Commissioners asked the Human Resources Department to conduct a survey of Colorado counties and municipalities with reference to their observance of Veterans Day. The reason for that is it came to the BOCC's attention from a Pickens County citizen questioning why the county did not observe Veterans Day and did observe Memorial Day. So we're here to present the results of our findings, which you should have in your package. So basically, we sent a survey to all Colorado counties and municipalities. We got a pretty significant response rate for our counties. We're looking at a 68% response rate. And of those counties, 95% overall recognize Veterans Day as a holiday. Pickens County, of course, was not included in this survey. Municipality rate slightly lower, of course, but nonetheless, there's still an 80% recognition of Veterans Day throughout the state. So the question becomes, should Pickens County recognize Veterans Day as a holiday, observe the holiday through closure of non-essential county services? Moving forward, and I've provided some historical information for you in the MOI with reference to Pickens County not having observed Veterans Day in the past. We have observed Columbus Day. We substituted the day after Thanksgiving for that holiday, so we basically now observe 8 of the 10 federal holidays.
If I may, just add, we did have a very brief discussion about this in the leadership team, and in that discussion, I think there were some different concerns, but overall, I think there was support for observing Veterans Day. I think some folks felt very passionate about it, that it was something that we should be doing as an organization. I also think the general thought, again, it was a brief discussion, was that if the board were to choose to look at recognizing Veterans Day, that we probably would not look at adding to our admin leave time.
That's correct.
It would be a requirement, it'd be a required day off within our current administrative leave allocation, so you wouldn't be adding additional time off for employees. You would be, designating that they do have to take this day off, though, for non-essential.
And I might add, we do have a policy for our new hires that have not accrued enough annual leave at this point to be, to not have it be a financial burden for them. The county does allow new hires with less than 3 months of service to go into a negative balance, so there's not a financial hardship presented for this particular holiday, or any holiday for that matter.
So at some level, it eats into an employee's discretionary time off, which they might use to schedule a vacation or whatever. But, so they would be required to, if they want to keep the full paycheck, use some of their discretionary hours instead of time away, travel, or whatever family obligations they have.
That is correct, Rachel. And in addition, employees do have the opportunity to request to work on any holiday if approved by their supervisor ahead of time. So that is another opportunity to manage that situation. I did do some calculations too, and our current annual leave balance is on average per employee. And we're currently at approximately 146 hours of annual leave per employee through 7/30. So that, and then if we look at our accrual rate for the county, it's very generous. We accrue for less than 5 years of service. The
holiday hours would equate to 64 current state, 72 hours if we go and add Veterans Day as a holiday. We still, with less than 5 years of service, our employees are earning almost 2 weeks of annual leave or paid time off during the year. With greater than 5 years of service, 3.99 or almost 4 weeks for the year. That will drop to 2.62 weeks if we should go to a 72-hour per year holiday allotment, and 3.79 hours at 72 hours of holiday pay for our employees greater than 5 years of service.
And I would just add, if the board were to consider adding Veterans Day, I would recommend adding it to our 2012 holiday list, not necessarily for this year, as folks have probably already made some planning, but that would be up to you.
Board, what's your pleasure? I'd weigh in, but Jack, go ahead.
Yeah, I certainly don't have a problem. It almost feels like an oversight that we didn't include that with Veterans Day, since it's a national holiday. I would not want that to occur for Columbus Day, because there's too much controversy about who discovered America first, so let's get that one off the table. But I'd like to ask a question. You indicated 3-point-something weeks for someone that is here up to 5 years. Now, I divided 40 hours into 176.8 and got 4.42 weeks.
I actually subtracted the holiday allotment as if it were a holiday benefit tied in there.
More of adjustment.
That's
Okay.
correct.
So how do accrual hours work? And this is a bit expansive, but an opportunity to get a little more updated, because I forget this stuff.
Yes.
Thankfully, we don't deal with it all.
Yeah.
So how does accrual work? After, at the end of a year, you accrue X amount of hours. For example, a person who's here 5 or less years can accrue up to 176 hours per year.
Correct.
Is there some point in time where if you don't use them, you lose them?
Yes.
And how would you explain that?
Absolutely. I'll refer to my employee handbook. So you're referring to a vacation.
Well, or a separation, if you happen to choose to leave employment. What does that mean relative to hours accrued that have not expired? So there's questions within a question.
Now, you did include this in our materials of the accrual maximums. So there's no carryover after that maximum. They just start to expire if you haven't used them.
So that's a per year?
No, I think that's a total.
Total.
It's 176.8 hours per year is the most you could accrue during the course of the year, working that many 40-hour weeks in the year. And then if you were carrying it forward from one year to the next, because you hadn't used them all, 280 hours is the maximum that you can ever have in your account.
And so 280 in this memo?
Yeah, it's the last column. I don't know what happens if someone is
It
determined.
accrues up to that, that's always a maximum.
That's always the maximum.
And with difference in 5 or more, 5 or less. Okay.
Yeah.
Yeah, I somehow didn't focus on that, so that does answer my question. So, say someone has accrued the 280 hours, worked for less than 5 years, and they choose to leave the job and go somewhere else. That would be a payout
That's correct.
at whatever their hourly rate is,
That's
or
correct.
salaried rate.
Yes.
Okay. And if they're salaried, that would be divided by 40? And then that determines
Yeah, basically.
relative
hourly rate.
percentages?
Yeah, exactly.
Thank you. I appreciate that clarification.
Are others supportive of adding Veterans Day as a holiday to our agenda? Michael?
Yeah, there's two discussions here. It seems to me there's one discussion internally about the effects on on the county employees. And there's another discussion, which is Veterans Day worth observing? And it seems to me, just on that basis, it's yes. And then, you can do modifications, it seems to me, that if it does fall on the weekend, that there is no day off. You don't take that Monday or Friday off. And, that's that internal discussion. But I think in terms of observance, we should observe it as Veterans Day.
If it's a Monday through Friday day, for sure. Okay. Rob?
Yeah, and I would probably add to that a little subtitle thing that how do we say is the proper way to observe our veterans? Is it from, having the day off and going hiking a mountain, or is it, having a lunch picnic, in Veterans Park and, observing it as a community and a workforce together, but having it be a work day. I'm not sure what the answer is to that, but I'm not sure that observance is about having a day off. The question that I have, though, for you is, you said that there was positive feedback to having this as an additional holiday? Because it seems to me that from an employee standpoint, this restricts their use of their vacation days. If someone uses their days, this is a used day, and then they want to take a long weekend and they don't have any days left because they've used this day, then...
Well, maybe I can answer that. We have not gone out and had a discussion with employees. This was simply the leadership team, which was section leaders, and I think that discussion really fell along the lines of what Michael was bringing up about, is this a holiday that we should observe at the same level of other national holidays for which we do shut down the non-essential county services as an observance. And so it was a very small group. I think we may get a different reaction when we go out to employees, and that's why I was suggesting that we start at 2012, so we have time to talk to employees about the reasons why and that sort of thing, if the board chooses to go that direction.
George?
Yeah, I'm supportive of it. I think it's more important that we are recognizing the importance of Veterans Day versus trying to tell someone how they should observe Veterans Day. I mean, we don't tell someone how they should observe Martin Luther King Day or Memorial Day or Christmas.
Or Thanksgiving.
Thanksgiving. I'm surprised we don't have a Hanukkah Day in here, but anyway, I'm supportive of this, and I would just like to say it's pretty interesting. I think that this request came to us from a citizen, and it just goes to show you what one person can do. One person can make a difference by voicing their concerns, and I welcome that.
I agree with that statement, George. I don't know if the policy evolved when we were a country that really wasn't actively involved in war as much as we are now, and it kind of fell by the wayside. As Jack said, it seemed more like an oversight than anything. And to me, it's less about, okay, the employees have a holiday. It's more the closing of public offices in respect of the day. That's why, that's the main observance, is that, it's theoretically that you shouldn't do business today, and everyone in the community should be able to go out and put some wreaths on the graves of those they know or whatever. But it's more about saying this is not a business as usual day. Today is of special significance, and somewhere in the course of the day, you're supposed to, give a little thought to the sacrifices that have allowed the smooth operation of governments or these sort of things. So it's, that's what I interpret it more as opposed to us fostering a community event, as much as just saying out of respect to everyone out there and respect for the day itself, it's not business as usual today. let's kind of see. I mean, if we have, huge feedback, we'll take another look at that. And I think it might be helpful for us, taking a look going forward. We're catching up on so many things and then reviewing them, but to get a sense of where do we stand with the benefit package for vacation accrual in terms of the overall market as well. I think it's something that Pickens County has been, as she said, a little generous on in the past, but it's always been, my understanding has been part of the observation of why people live here and move here, and that it'd be very hard to get good people here if they could not, save their vacation time and go when their kid has experimental ed or, those sort of things. And we were always lagging behind in salary, and so at least we could offer something else for these things. But I think that would be just a good kind of overview at some point in time.
Happy to.
Especially as we're looking at budgets coming up in the next year.
And I assume 2012 is okay for the start, or?
Is there any objections to if this policy is implemented to start it in 2012, not 2011?
I think that makes sense, given that Veterans Day is just a couple of months away. Yeah. People may make plans and
use their days.
Use their days, yeah.
Okay.
May I clarify?
Check.
Am I hearing that also leadership is going to go and get feedback from staff, or?
Well, I think...
Because, let me just...
Oh, I'm sorry, Jack.
Because I feel that this is somewhat of an oversight, and golly, you just somehow don't pay attention. The greater community, respects it and observes it in whatever ways they do, but, in particular next door. I'd just soon implement it. That's my idea.
And I believe that's the direction we're getting, but what it does do is it gives us some time to explain the change to employees and that sort of thing.
Also. I just want to make sure I knew what I heard.
Sure. You may get feedback whether we ask for it or not.
That's right. Okay, so we've got that. We now go on to no more memos of interest. So we're on the future agenda.
Okay. We actually printed out new future agendas for you, but first, what I want to hand out is a budget calendar, a meeting calendar for the budget season coming up, so you can see what we're looking at, and I just want to make sure you're comfortable with at a high level how we're approaching things this year. You will not see these right now in the future agendas that were distributed in the packet. I have a new set to hand out where these have been added in. I'll just walk through real quick. Our first meeting is really to review revenue assumptions again, another check-in with the Financial Advisory Board, and that will be on September 6th. That will be followed by October 11th, presenting to you an overall budget summary of what staff is recommending for the 2012 budget. At that time, again, we'll look at the context of what's happening in the community, the projections, service level demand changes, and then looking at, again, our revenues and resources, and then how our proposed expenditures line up, and we'll give you some highlights. That then will be followed by several opportunities, and by the way, that October 11th meeting meets our statutory requirement to have a proposed budget submitted to the board by October 15th. That will be followed in October and November, a series of meetings where we bring in individual departments, so that you see the first one is the district attorney. We'll have a joint meeting with the city on our areas of joint budgetary concern, an EOTC meeting, an ambulance district meeting, and then you'll see on October 25th these more general areas
We're going to have departments come in and present and discuss budgets to you based on where they lined up in those core areas in the strategic plan. So we're trying to group it a little bit by outcomes, have some logical groupings really in the general fund. So you'll see first core focus area, second core focus area, and third core focus area. We're going to sequence those based on, we're still sorting through where the department budgets fall in those core areas and seeing where we might need more time to have discussion. We'll probably have the more complex discussion early on in case we need some follow-up, followed by what we perceive to be the less complex. At any rate, it really culminates on November 15th after you've had a chance to visit with departments and such about their budget proposals. We'll have all funds decision points where we can make any modifications that the board is wishing to make to the proposed budget at that time. And then we'll bring a first reading to the budget to you on December 7th. That will be at a regular meeting. And then we will bring the second reading and adoption of the budget December 13th. That's actually one of our Tuesday meetings, so we'll just hold that as a special meeting with certification of mill levies to be done by the 21st. The statutory requirement is that you adopt a budget by December 15th, so that keeps us within those statutory guidelines. So I wanted to put that out to you so you kind of could see the big picture, because you're going to start seeing these sprinkled in future agendas, and this is covering a time frame beyond that.
Okay. The only real observation I have here is that you being our new manager, Bob, a new makeup to council, to the commission, I'm not sure that we're not going to need more time on some of these big issue items. And so, you know, I'm still trying to figure out where within those core budget areas these larger things that we're now talking about, road capital plan, building capital plan, and other capital plan, how they're going to weave together. So that's just a short observation, but sometimes an hour is really tight. And I know the joint meeting with the city, when it's information technology, housing, I could see both of those almost taking an hour worth of time up as opposed to those and Health and Human Service within 2 hours. So, you know, if we have really tight agendas, we'll probably get through those, but it doesn't leave a lot of time for questions and debating different strategies.
Yeah, and you're gonna see a lot of that detail, Rachel, even in that first meeting when we talk about that high-level budget overview. That will include our operating by fund, but it will also include a review of our capital plan at that time. And so then we'll have an opportunity as we go into the core focus areas to even have more time to dig into specific projects that you might have concerns about, because all of the departments are going to fall in those areas. And so my hope is that as we go through, we spend this almost 4 hours on October 11th going over the summary, that is going to give you enough detail at that point that you'll be able to start asking some pointed questions that we can focus on as we get into the core focus areas. But we can try and find more time. We are having some difficulty finding time in your schedules through October anyway. It's already...
Yeah, and I'll leave this for your consideration as we go to the next future agendas discussion a week from now or whatever. But it may be worth holding a Wednesday. That's one of our non-Wednesday meeting days for, you know, overflow items, carryover items, or things that need further discussion. And so, you know, I just want to make sure that when we get to the adoption, people feel that it's been thoroughly vetted, thoroughly discussed. We may or may not all agree with all points of the budget, but that we have enough time, and that time hasn't been the issue.
Sure.
You know, so, you know, we can talk about that, and, you know, I would think, you know, something earlier in November, like the Wednesday the 9th, might be worth holding on to. so that we're not backed up into right against that statutory deadline in December. But again, if you need more time, or we could look to a Monday in the beginning of December as well, if we need more time.
And more time is better.
Yeah, George?
One of the issues that we'll need to discuss as a board prior to meeting jointly with the City Council on the budget with housing, health and human services, and IT.
I'm sorry, George, I didn't understand that.
Well, I'm just curious, will there be issues that we should be apprised of prior to our meeting with the City Council on these joint areas?
Yeah, and you're going to be getting some, we're actually working out a number of areas, looking at our information type. So we'll be laying out highlighting some of those areas for you when we bring the summary. If we think there's something that we need to spend a little more time on, we may do an MOI or have a discussion with you guys before we go into the joint meeting. But we're obviously going to be having a discussion on housing, because to me right now, at least from where I sit, that's kind of the biggest question mark I have about where we sit and where we want to go in the future. I think we're going to have a good set of recommendations for you on information technology and health and human service agencies. We're suggesting some changes to our future budgets there.
Okay, but that is a good observation, George, that we may need to work some agenda time in prior to that, so we're all on the same page. Michael?
The same goes for the City Council.
Yeah, I'd like to see them all on the same page.
Well, I'd like us to be able to have a conversation, and if they're not apprised of whatever their concerns are, we're not going to have a very good conversation. In fact, we rarely have a good conversation.
So you're thinking of sharing the MOIs that we would be looking at with Steve and CCing them to the city, and then, requesting that we're really able to see whatever MOIs they have on these topics as well.
Yeah, and right now staff has been, from the city and the county, we've had some preliminary meetings on housing and information technology and such, so that hasn't been reduced to writing at this point. But let me, to be honest with you, I'm not as familiar with the city's process, so need to see how those sync up.
Yeah.
Because this will be the first time we've ever done this.
Oh, no, we've done this before.
I've never been up with them on IT discussion, ever,
I
on
think
budget.
IT may have been added, but we've definitely done joint on housing.
Yeah, but not on the budget consideration. We've talked about it, but not how it figures in our budget.
We always have, because we share the housing budget 50-50. And we absolutely have had joint budget meetings on shared departments before.
Yeah, because I remember, because I specifically questioned the cities was putting in, within their budget, some dollars to housing city employees that was coming out of our joint IT budget. And I was concerned about
That was last year.
That was last year. And I don't know if that was ever resolved, frankly, but I know...
I think they dropped the request that it be part of the joint budget.
I caught that on a line item, and so I know we discussed it.
Yeah, my understanding is there have been joint meetings in the past. I don't know if they've all been consolidated like this, and it's very clear to me that from the housing and IT IGAs, those are budgets that we adopt and should be discussing together, so I wanted to be sure we captured that. And then the Health and Human Service Agency seems to be a practice that we've had where the city's relied, I think, on our grant review committee to make recommendations for the dollars that they dedicate.
Yeah, I remember they had the really good video clip that they put together last year that we kicked off that meeting with.
So I just wanted to, and we'll try and build in some more time, and if you, of course, if you have comments or concerns, we can still adjust this, but I wanted to get this out in front of you so you could see how we're approaching it this year.
The other question, I'm sorry, the other question that we'll see at some point, maybe the high-level budget overview, or with some of the special mill levies, whether it be library or open space?
Those are going to fall in, yeah, that will be, the overview will cover all funds. And so I want to be sure that you guys get an overall picture of the budget right away, so that if you have early on questions or concerns, we can be agile in the later meetings and answering those questions or doing more work. And then those departments will also come in the core areas. And so we're trying to realign it from talking about it by fund to starting to talk about it by what outcomes are we delivering. And so the NAMS group and the sheriff and maybe the library have common interests. Those groups will be coming in together.
Okay. Well, I think at the very least, looking at this one on the 18th, we might want to look at 4 to 7 and have an hour for each topic, and if we can end early, better. But, there's nothing worse than being 98% of the way through and people starting to leave to say, I thought we were leaving at 6, and that's one note I would really make. Those joint topics.
Some clarification, the housing under the October 18th agenda item is specific to APSHA, right?
Correct.
That budget.
That's correct. That's not our funds that we may want to use.
Or a bigger joint summit or...
No, it's APSHA.
Okay. And you had other new future agendas to give us?
Yeah, I apologize. So these were printed with the budget items added in. And we already have a change to a change.
Okay.
So let me start off just making sure we're on the same page. Next Tuesday, of course, is a special meeting.
Yeah, it's Tuesday the 23rd.
Yeah, Tuesday the 23rd. Correct, than what you had in your packet.
I have at least an outline here.
I don't know.
Do you have an extra one, John?
Oh, did you not get one?
Well, I got one.
I do?
No.
Sorry, Mike.
So we get rid of this.
So next week, of course, the 23rd, we're going to be moving what would have otherwise been covered on Wednesday to Tuesday, so we have the second reading of our ballot questions. September 7th, we have the work session on housing, and we also added the special meeting for the River Road Ranch. That's bringing that question back about what to do with the payment in lieu question.
Okay.
Can I ask you, as long as we're on September 7th, is that a working lunch, paper bag lunch?
We are going to make it a working lunch, bringing you guys and staff in. Versus, yeah.
May I also add that we need to add CCI's meetings of September 9th and 16th on the agendas. I asked that we do that about a month ago, but so, John, with the new agenda, you're pointing out changes, right?
Yeah,
That's what's going on.
September 20th is probably the day that has changed the most, and it's actually changed from this that I just handed out. We had talked to Gunnison County, and they had proposed September 20th as a date to do our joint meeting, and we were heading down Valley anyway. So we had talked to them about a afternoon meeting after visiting with GSS Properties. They did contact us late this morning right before lunch and said that we're hoping they could move that to the 27th now. And so we may be back to looking at holding that meeting at the Woody Creek Community Center if you guys are still interested in doing that. The other question that
The meeting with
On the 27th.
with Gunnison?
No, we're going to Gunnison on the 27th is what we're looking at now, so
Okay.
we'll have to move that agenda around.
Okay.
On the 20th, we were going to be going down to do a
Okay.
site visit to GSS Properties, and the
Then
board had
the rest of our
recommended-
work session.
Right,
Okay, gotcha.
maybe staying at Woody Creek Community Center.
Okay, yeah, no, I just
And
wasn't...
so we obviously need to make a bunch of changes there now to move items around from the 27th to the 20th.
Okay.
So, just to make sure, it looks like Gunnison will be potentially the 27th.
Correct.
Okay.
So we're still working with them. And sorry, we thought we had the date nailed down with them when we printed these off.
Okay. You know, I don't know if it's possible or not with the meeting with Gunnison, but there may be items of executive nature that we would like to share related to oil and gas leasing and regs and things like that. And so, you know, I think they would have to be scheduled to go into executive session and invite us into it. May not, you know, but, you know, they do have a lawsuit pending on their regs. And, you know, again, it may be something that's just best discussed, their attorney to our attorney. But just put that as a footnote to kind of clarify if that should be a part of that agenda.
Okay.
So John, on the 20th, for the revised, we might go back to some of the things that were already potentially here?
Yeah.
I mean, we're here.
Yes.
We're not.
Yes. I apologize for the confusion there. The one question you guys did have is on the original agenda, we had we had asked about maybe doing a site visit on the Lanedo historic designation. That, I think, for ComDev, that was premature, that, you know, the group's just, it's just an introduction. They haven't even come in to talk yet, so it wouldn't be appropriate to do a site visit at this point.
Okay.
And I think that's all we really had outside of the, you know, we added abatement hearings on Monday,
Yeah, that
September
is,
26th.
that would conflict with the 1177 roundtable for water for me, but you guys can conduct the abatement hearing without me, and I'll go down to the meeting in Glenwood, or you can look to change it, either way. That's always the fourth Monday of the month, but they skipped it this for August. George?
I thought last year when we met with Gunnison County Commissioners, we were talking,
They were talking about traveling over here.
traveling, our meeting was halfway, like in Redstone or Marble, since Marble's in Gunnison County.
You know, I think, and I don't know what happened last year, I think what Susan says, they came over here last year.
Oh, they did, that's right,
Yeah.
because they toured the airport, that's right.
And I could look at.
George is right. I mean, they did come over last year. Yeah.
So we're going quick pro quo.
Yeah, but we went there for years, so it kind of,
Yeah.
it's whatever.
If they're going to Nelson Marble or Redstone.
I can give Matthew a call. I think this was on one of their regular meetings.
schedules.
Yeah, I'm okay with it either way, but let's try to have as much clarification from our board beforehand, because occasionally we've gotten closer and closer to these field trips, and they drop off to only 2 members, and it gets a little embarrassing if we've asked them to schedule. So we should
Are we
confirm
going
our
to have a little
attendance.
prep for Gunnison?
Yeah, we'll get some prep time, and I've talked to their manager, and we have 3 items that I think we could take up the whole time. That would be of mutual interest.
Okay. Very good.
May I, John, one thing, because we're on September 20th, it's bounced around. It will be necessary, I'm glad we're not going to Gunnison, that at 5 o'clock, I will be done for the day as far as commissioner stuff, because I'm going out of state. So, just to give you a heads up,
Okay, so
I've already got reservations.
hard and fast, Jack leaves at 5 PM.
Yeah, or, 10 after, whatever, but not
Okay.
7 o'clock.
The only thing, last thing I want to draw your attention to is actually the last page, which is Monday, October 31st. You recall that Election Day this year falls on November 1st, and we don't have a meeting. We're hoping to do budget presentations on that day, so we're hoping to bring you in on Monday on Halloween. You could wear all kinds of great costumes related to budget cutting and such, or what have you, but wanted to check and make sure you guys were on board with doing that on Monday the 31st.
I'm okay with it. I think we should try to maybe end at 4 instead of 5, so if people have plans, they can go home and change out.
My kids would appreciate it.
Yeah. And so let's try to shorten that one up if we can, and maybe make that a work-through lunch, and make that a brown bag lunch, so we can do it, and just figure some other break time in between.
Okay.
Yeah, and that's the last night of finish-up campaigning.
That's certainly true, too. But who's going to take a phone call on Halloween night?
That's all I have for you guys.
Okay, does anybody else have any times they know they're going to be out of town that they've not expressed yet, or heads up for meetings they won't make, so be sure to have a quorum. Okay, then let's go on to the next part of our agenda, which would be open discussion.
And I just have one item which we already covered, which was the email from Sloan.
Okay. Anywhere else? George?
Well, do we want to make an appointment for conflict?
Yeah.
About the Ritter?
I think that I would be supportive. Others? Yep. There we go.
Thank you, George. I should have brought that up.
Okay.
So would that make it on time for the resolution when we do Neil as well?
On Tuesday of next week?
Next week?
We could.
Yeah, I think we can make that happen.
Yeah. And then, just as kind of a heads-up reminder, we do have our volunteer appreciation party next Tuesday at 5 PM, and that's going to be right here? Okay. And so, we've talked about it before, but I really want to make sure that we've asked people on those boards that don't meet all that often.
Okay.
And to really make sure that they know they're included in that invitation, and even though we haven't had to call on your services in the past year, feel free to come and meet some of your fellow volunteers and county citizens, things like that. So try to see how that goes, and bring your spouses or kids if you'd like to. And we'll make sure we have food this year. Or else that caterer is gone. And, okay, did anybody else have any other open discussion items today? Not seeing any nods. Jack, do you have anything? No. Well, then we're adjourned a little early. First time in a while. Thanks, everybody.
Thank you. Yeah, half an hour makes up for the 5 hours of over.
Yeah.